Oh, hello, how are we, beautiful people? How are you? Hope you all had a nice lunch or dinner, whatever you had. Um, I'm just trying to sort this out. Yeah, well, I had a nice dinner, so I'm refreshed. I'm wicked smart, I am. Wicked smart. Sarah P with all the links, look at that. I messaged with Sarah P just now. So we've been back and forth. She's hoping to come back tomorrow or Friday to see you all. She misses chat. We miss her. So I'll be nice for her. I'll be nice to her for like all of 5 minutes, and then back to her usual selves then. But yeah, we miss Sarah P. But she's gonna be back. Oh, look at the timing. Look at the fucking timing, everybody. What's going on?
Just quick approach.
Approach straight for a fucking sidebar. Right, okay, let me get this sorted then. So just as a reminder, we're going to be watching after this. There'll be the what you call it closings. Oh, let me mute this fucker. It'll be closings after now, then finishing jury instructions, I think, and then what's going to happen is we'll go and watch Colin Gray for an hour and a half, whilst I still keep an eye out for this, and then there's day one of a certain trial I want to do. Hello, Tootsie Wootsie. Hello, my darling. Hope you're well. Jeepers, I lost my voice there. Our new trial, I'll do day one. Maybe we'll do day two today as well. I don't know. Depends on the verdict. No worries, hippie chick. We shall see you in a little bit, my darling. Those meetings, how rude of them. So yeah, well, that's what the plan is. We're gonna Colin Gray, I believe that's the father of the young guy who was shot in the school, and then in Georgia, and then we'll look at the next new trial, which will either catch up on all today or we'll do it tomorrow. I don't know. We'll see. Depends on how quick we get a verdict from this trial. You know, I know people think it's an easy, it's fucking guilty or go across. There's so much fucking charges here, you know, for you to go through. You know, hey Deb, oh my darling, it's gonna take maybe a while because I'm wicked smart, so I know this. Right, here we go then. What's happening here?
Jury's ready. Let's bring them in.
Jury's ready. Let's bring
Now,
them
I'm
in.
going to say, hey, Kyle, hold on.
Okay.
Sorry. We put this down here so y'all can hear me. Can everybody hear me? If there's any outbursts at any time during the state's closing, the defendant's closing, the state's rebuttal, I'll clear the whole courtroom. All right? Now we can jury.
I still think he's got some pages to read, but we got this now. We don't know how long they're going to have. Not too long, hopefully. Fuck me. To close. Jeepers. Hey, Robin. We'll see now. I hope you all had an eventful lunch. I mean, some of you probably spent it on Twitter, seen all the Carol Reed stuff. There's loads of filings and stuff like that. I've just given up on it. We'll see what happens. Outbursts during closings, that doesn't usually happen. I think it's more the fact on this occasion they'll probably be maybe showing some of the pictures and stuff.
You've got
Maybe just emotional outburst, he means. But you're right, though, it doesn't normally happen. I'm just thinking maybe that's the reason. It's very strange. I've never seen an outburst before. So maybe he has. I have no idea, really. You had pizza. Hello, Lazy Die. I had, what I had for lunch was, when you get in the freezer and you've always got bits and bobs. So I'd like chicken with some sour sauce in it, hash browns, and stuff like that. I had a bit of everything, which was nice. It was mixed together. It was nice, and then I had some pavlova and ice cream just to finish it all off. So it was all like everything I had in the freezer, just put it on the tray, Verdict reading, yes, but not good. It must be something. He must have experienced it before he did that. It must have happened, outburst in the court. It's not, I agree, it's not very likely, but it must have happened. Or he's preempting here because of the emotions in the courtroom. I don't know. Because, it's very emotive as well, do you know what I mean? So, smorgasbord. What's smorgasbord? Is that like a bit of everything thingy? It's nice. It gets rid of I got rid of like 4 or 5 bags. Chicken nuggets, it only had like 5 of them. But just gets rid of everything. I have no idea. You know what I mean? It's nice. Get a bit of space now. Ashley McNamara, hello, my darling. Nothing. We're just going to closings now, so you missed nothing. Right, here we go, people. Strap on. Sorry, strap in. I meant not strap on.
I'm going to leave this up if that's okay, Your Honor.
Right.
Thank you.
Okay, they've got exhibits. Okay, maybe that's why then.
So we've finally reached the point in trial for closing arguments. And what this essentially means is it's an opportunity for the state of Tennessee to go through, talk about the evidence a little bit, reflect on some of the witnesses, because it's been a pretty long, almost 2 weeks. The state will go first, then one of the defense attorneys will have an opportunity to go, then the state will go again. And Matt, I'll talk a little more about that in a second, but that's because the state carries the burden of proof. So I think each of you should have a jury instruction pamphlet in front of you. I'm going to ask you if you flip to page number 6, it covers the burden of proof. And it seems like it's a common misnomer for the burden of proof to appear to be higher than it actually is for the state of Tennessee. And don't get me wrong, it is a high burden, and we gladly carry that burden every step of the way. But when you read about reasonable doubt, and that, of course, the burden never shifts to the defense. The burden is always on the state of Tennessee. It is a burden. It's not absolute certainty. It does not require you to say, I don't know 100% what happened. That is not what is required by the law. It is not absolute certainty. It's essentially, can you go to bed and let your mind rest easy? Can you, actually, I'm going to do one other thing real quick. What I'm asking you to do is essentially use your own common sense. That's one of the most important things. Okay. And I'm going to give an example of what I mean by this, if I can. It's like Wheel of Fortune. Okay? My handwriting's not the best though. But you get the idea here. It's like Wheel of Fortune. When you see a contestant on Wheel of Fortune and they know the answer to the phrase or the statement, they don't have all the letters when they see that phrase, but they know what the answer is. And if the state has done that, we have met our burden. And it's important to note that it's not beyond a shadow of a doubt. It's not absolute certainty. That is not what is required by the law, by the state of Tennessee. So that brings me to some of the arguments that Mr. Scott has made through this trial. They might be on that same page. Probably should have written. Here it is, page 5. In your instructions, in the second paragraph, it states, Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. And I beg you to remember that. When Mr. Scott gets back up and makes his arguments, remember that. The things that come out of his mouth and that came out of his mouth during trial, that is not the evidence. He tried to get you to speculate on so many things during this trial. He wanted to throw out strange theories with aluminum foil. He wanted to throw out a term that doesn't even matter anymore, SIDS. That came from his mouth, not either of the doctors, but from Mr. Scott. He's asking you to speculate. That is not evidence. I beg you to only think about the items that were put into evidence, the photographs, the recordings, and what came from the witness stand. Do not let them sway you from what actually happened in this case. He kept mentioning cadaver dogs. He wanted you to think about that. But if you remember the cadaver dogs, Tommy Boswell, on his property, what did we hear him say? The cadaver dogs didn't even go up there by the playhouse. He wants you to believe maybe the body wasn't there at that time. He's trying to throw you off, but he didn't show anything. There's no proof. There's no evidence.
Oh, wow. I don't know, Maxie, but wow.
Ladies and gentlemen, I want to remind you once again, and it's in here in these instructions, that the defendant has no burden to prove anything during this trial. The burden is wholly on the state of Tennessee. Okay? Go ahead, John.
Thank you. And I believe I said that. The state, we gladly carry this burden. But again, what comes out of Mr. Scott's mouth is not evidence. You heard nothing from the witness stand about cadaver dogs. There's no piece of evidence about cadaver dogs. And Mr. Scott said in his opening statement, humans make mistakes. Do you remember that? Dogs also commit mistakes. And if you remember, Agent Fraley and Agent Gratz, both with the TBI, what did they say? They didn't smell anything in that playhouse until they lifted the black bag, and immediately the smell of decomposition hit them. I submit to you, cadaver dogs, what do they work off of? The smell of decomposition. Don't let that fool you. Mr. Scott also talked a lot about Hunter Wood. We heard a lot about Mr. Wood in this trial. Again, did we hear any witness from the witness stand that ever saw Evelyn with Hunter Wood? There wasn't a witness that ever saw Evelyn with Hunter Wood. And if you remember the text messages that we saw yesterday from essentially Hunter's own mouth, it's pretty clear that he's yet another victim of Megan Boswell. She was feeding him the same lines that she was feeding every other person in this case. Mr. Scott brought up the theory of an accident, or the word SIDS. Well, you heard Dr. Malushnik say that in the past 10 years in the state of Tennessee, a child 12 months or older has not passed away from SIDS or sudden unexplained death. Those are statistics from the state of Tennessee. But somehow Mr. Scott wants you to believe that somehow that's how this baby died, even though she has foil wrapped around her head, a blanket wrapped around that, inside a trash bag, upside down, in a trash can. Let's go through our timeline just for a minute. What do we know? We know that Evelyn was okay until November of 2019. We know that Evelyn was seen at Thanksgiving by family. And then Megan Boswell started a new job at the Chicken Shack. What do we know after that? Megan Boswell meets Hunter Wood. And we know that Sue Whitson is probably the last person to ever see Evelyn alive again. You remember the picture that Sue took? This is very likely the very last picture of Evelyn Boswell alive. Not taken by Megan Boswell, but taken by the babysitter. Sue Whitson testified that the last time she babysat was the end of November, early December, which just so happened to coincide with when Megan Boswell met Hunter Wood, a guy that she was hoping might change her life. But Evelyn was in the way. What did we hear? Do you remember Megan's friend, Maddie Broom? We heard a little bit about her. Her brother, Stephen Lawrence, tried to help Megan. She drove her to a few of the interviews. And if you remember, Megan was apartment shopping on December 8th. And on that date, Evelyn was not with her. And so Stephen asked her later, after it's been reported that Evelyn's missing, he says, was Evelyn gone by then? And what did Megan say? Yes, Evelyn was gone by then. So that takes our window from December 3rd, essentially when Megan Boswell started working at the Chicken Shack, to December 8th. Evelyn Boswell's 12-month well visit. Do you remember that? Scheduled for December 5th. Megan doesn't call and cancel. She just no-shows. And Casey Saltz, the receptionist there, had to reach out and ask Megan, and Megan gave some excuse, I can't remember what it was, as to why she couldn't bring her. So they rescheduled for the next day. Did Megan show up with Evelyn the next day? No, she didn't. I submit to you, that's because Evelyn was already gone at that point. Casey texts Megan again, and Megan has yet another excuse. The appointment's rescheduled one more time for December 11th, and conveniently, Megan then says, oh, I've decided to change pediatricians. And as we can all imagine, when you change pediatricians, we all know that children have vaccine records and all of the things that come with being, especially that first 12 months of life. They've got a lot of appointments and a lot of vaccinations. So it'd be really, really important to transfer that information to the new pediatrician. Did Megan Boswell do that? No, she didn't. They never got a request from another pediatrician. That was just another line that Megan Boswell told to start trying, I say trying, to cover her tracks. We also know that on December 7th, you saw a text message yesterday from a girl named Haley Marie, and that is the very first time that Megan tells the story her dad has her. December 7th. Keep in mind, Sue Whitson saw Evelyn alive for the last time, and then Megan just stopped showing up. And then by December 7th, she's concocted her plan. And it really explains why so much time goes by. Because I know that's a question we have all had. 2.5 months goes by. 2.5 months. But now we know. We know why. Because Megan Boswell was telling every single person in her family and her closest friends that Evelyn was with her father. So what does a rational person think? Okay, we're glad. I think Tommy even said that from the stand. I was proud of him for stepping up. I was proud of him for stepping up and taking responsibility. But, time continues to pass, and you've heard witnesses, in particularly Bailey and Audrey, Megan's closest friends. They were all starting to talk and to think like something doesn't feel right. Just doesn't feel right. But no one could have known how wrong this was at the time. February 2020, finally, Tommy Boswell says, I've had enough. I want to see my granddaughter. Show her to me by tomorrow, or I'm reporting it to DCS. Well, Megan couldn't do that. Megan knew she couldn't do that because she knew where Evelyn was. We all know where Evelyn was. And so Megan did not produce Evelyn that day. And Tommy finally gets the ball rolling on trying to find this little girl. And they first show up at Hunter Wood's house on the lake in a nice neighborhood. And Megan Boswell's there. But there's no baby. There's no Evelyn. And you remember, the only thing Megan, you remember James Lewis from DCS, the only thing Megan was really able to show was this box from Hunter's bedroom. And you remember what Megan called that box? A memory box. Now, why would you call something a memory box if you were alleging that your child is still alive? This is all Megan Boswell had of Evelyn in that house that she was trying to show DCS that Evelyn was living in. She couldn't show him diapers. She couldn't show him a pack and play. She showed him one outfit that she held up on a hanger, not an outfit that Evelyn had ever worn. There was no evidence that a child had ever been in that house. Now, I'm going to touch on something briefly. If you remember Paul Durant yesterday, going back and trying to just give you a little bit of a timeline. If you remember, he talked about Ethan Perry in the military because Megan Boswell led him to believe that he was the father, even though he had his doubts. She convinced him that he was the father of Evelyn. We know he was not the father. We know that. And he said she was sharing photos daily, constantly sharing photos. Until what day? Do you remember the date? December 3rd. On December 3rd, Megan Boswell stopped sharing photographs of Evelyn. And she continues to send pictures, but if you remember, Agent Durant he's a smart guy. And so he was able to check her full Facebook extraction. And so she continued to send pictures to Ethan, but they weren't recent pictures. It was just another way that she could try to keep this facade going just as long as she could. Mr. Scott wants you to believe that Megan Boswell had a rough life. She was in foster care. But Megan Boswell was in foster care because of Megan Boswell, because she would not go to school. She went to foster care because she was truant. And when she left foster care, she went and lived with her dad. And of course, Evelyn was a baby at this point. I think the testimony was from February to March of 2019. And then her dad said, I'm going to get her a trailer, set her up. He bought her a brand new car, buys her a trailer. He's giving her everything she needs to raise this child. And she goes and lives with her mommy, her grandmother, from April until October of 2019. And then finally into the trailer from October to December. I think it's fair to say that she did not live in that trailer with Evelyn for very long. But in that short period of time, this is what she was able to do to that trailer. Can we look at that for a second? That's what she had her child living in. If that's not neglect, she does this in 2 months. Ladies and gentlemen, I beg you to look at these pictures when you go back in the jury room. That, in 2 months, is what the defendant was able to do to the home her dad provided for her and her child. And within 2 months, Evelyn was dead. And I stated there are, maybe it's just my opinion, there are a lot of victims in this case. Bailey Hawkins, her very best friend. Did you see how difficult it was for Bailey to testify? To look at someone that she trusted, that she loved. Audrey Gibbs, same thing. They are also victims of Megan Boswell. And they will also suffer for the rest of their lives because of what Megan Boswell the web that she created for them all to get caught in. Erica Stacy, who cared about Megan and Evelyn so much, is a victim. Gail Kite, the foster mother, she's a victim. Ethan Perry, who's serving his country, doing absolutely nothing other than his job, gets pulled up into Megan Boswell's web because Megan Boswell is only worried about Megan Boswell. And I'll submit to you that Hunter Wood, the person that they would like to blame somehow, is also a victim of Megan Boswell. She starts with first blaming Ethan Perry. She does that for a few days. And when she quickly realizes, gosh, law enforcement can figure out that I'm not telling the truth here, I guess I better tell something different, then she goes to her mom. She blames her mom, her own mother. She's willing to blame all the time knowing. I mean, we know, let's find the picture. We know where Evelyn was.
That is them. Right, let me try and see if I get another stream then. That is them. I don't know what's wrong with that. Why it's gone. Oh, they come back.
There she is. Evelyn Boswell sat there in that trash can for 2.5 months. And her mom discarded her, not just Evelyn, but everything that was associated with Evelyn. Everything. Because she didn't need it anymore. Everything. She didn't need that stroller anymore, so she left it behind. She didn't need the clothing. Do you remember all the pictures that came in and all of that stuff that was in that shed? Because she didn't need it anymore, because she knew where Evelyn was. The defense wants you to believe that Hunter Wood is the one that backed Megan's car up to that shed in the middle of the day. In the middle of the day, Hunter's just going to go over there. He has a truck. The testimony was that Hunter had a big truck. Now, why in the world, if he had a truck, I mean, this clearly took more than one trip. I guarantee you, look at all this stuff. They want you to believe that Hunter Wood backed Megan Boswell's car up to that shed that day. Tommy came home. It was in the middle of the day. Where's the diagram? Do you remember the diagram of the scene? Look at this diagram. They somehow want you to believe that Hunter Wood pulls up this driveway and comes to this shed right here, right in front of Omani's house. Tommy's house up on the hill in the middle of the day. Is that reasonable? What is reasonable? How about that Megan Boswell is the one who drove her own vehicle, the vehicle her dad bought for her, up to that shed, because Megan Boswell is the one who had a key fob. Remember, there's a gate there that only opens with a key fob. That's the only way a car is coming through that driveway. And Megan Boswell lived there. You just heard that she lived at her dad's house and at Omami's house. And so they're not going to be surprised if Megan Boswell is on the property. She's the one who dumped Evelyn's property there. She's the one who took the trash can there. Not Hunter, not anyone else. It's Megan Boswell. Do you remember there was more than one text message? And of course, keep in mind, the whole time these text messages are coming through, that's where Evelyn is, okay? Just think about that for a second. I'm not going to take the time to go through these because you can do that. You can go, you get to take all of this back with you into the jury room. I encourage you to go back and read all of these text messages and remember the dates that we've talked about. But while Evelyn Boswell is sitting in this trash can and people are asking Megan, how's Evelyn? What does Megan say more than once? Mean as fuck. First of all, she's a 12-month-old child. And every other witness said that she was a lovely child to be around. And it's not a very nice statement to begin with, but it's definitely not a very nice statement when your kid is shoved down into a trash can upside down. And you know that. Agent Fraley was on the stand, and you heard Megan Boswell admit that she knew Evelyn was dead. She's telling all of those stories to law enforcement. And she told more than one person, Evelyn's mean as fuck. And when Agent Grass asked her about it, she goes, what's your point? What's your point? And that's an interview with Agent Grass that you can also go back and watch if you'd like to do that. So we saw the defendant enjoyed crying during this trial because she has an audience and she really enjoys that. But did we see her crying any other time? Did we see her crying from the witnesses on the witness stand and what they told us about her? Did we see her crying in the evidence that came in? No, Megan wasn't crying. Do you think she was crying when she filled out this apartment application with Hunter Wood, where they list 3 occupants are going to live in the apartment? And at first glance, we're like, oh, Megan, Hunter, and Evelyn. But that's not what the defendant told David Gratz. Do you remember what she told him? She said the 3rd occupant is the baby she's pregnant with because Hunter doesn't want Evelyn to live with him. Of course, we could also look at the date on that application, January 4th of 2020. And we also know another reason that Evelyn would not be living with them. Was Megan crying here? In 2020, when she posts on Instagram, so excited for our new home. You think Megan was crying when she posted that? To me, it looks like maybe Megan's just moving on with her life. As if Evelyn never even existed. What about here? Also posted in 2020. Keep in mind, Evelyn's still upside down in a trash can because Megan's not told anyone where she is. She's still spinning her lies. Do you think she sat here when she's picking out furniture for their new house? That she's sad today? She has the gall to sit here and cry today and pretend she can't look at the pictures of what she did to her child? What about this one? Proud of my baby. New 2020 High Country. Was she sad then? What about in December? Weeks after Evelyn has been brutally murdered. What is Megan Boswell doing? Does she look, maybe we should zoom in. Does she look sad here? Maybe she is. Sure doesn't look like it. Her kid's upside down in a trash can. She's going to the aquarium with her new boyfriend. What about here? She doesn't look very sad to me. Hiking in Blowing Rock in 2020. No Evelyn. Evelyn's missing. Still missing at this time. There's Megan hiking with her new boyfriend, moving on with her life. Not crying. Maybe Megan Boswell didn't have an end game. Maybe she didn't know. Maybe she hoped that Evelyn would never be found. But she had to know at some point these stories were going to catch up with her. Ladies and gentlemen, and I'm asking you today, 5 years later, February 2025, to show Megan Boswell that her stories have caught up with her. The evidence shows the defendant. This person is the only person responsible for her child being dead. You heard it straight from Dr. Malushnik. Evelyn shouldn't be dead. Evelyn should not be dead. I believe the defense brought up SIDS, reflux, rollover. I believe they even brought up a tongue tie as being a possible cause of death for Evelyn. How does that result? Any of those things. You know, he said in the beginning, the state can't even prove how she died. Are you kidding me? How does that end up with a baby in a trash can? The DNA. Let's talk about the DNA for a second. You've got the gloves that are in the trash can. And the defense somehow wants you to believe that gloves will keep fingerprints from happening. And then I guess whoever did that then took the gloves off, cut them up because they're cut up in small pieces and you can look at them when you get back there, and then dispose of them in the same trash can that the baby's in. That doesn't make sense. That doesn't make sense. And funny enough, guess what is there? Is DNA that matches Megan Boswell, that matches Evelyn. Go back through the testimony. There's not one piece of DNA, not one, that shows anyone, not Hunter Wood, not anyone else other than Megan Boswell is associated with that trash can, the evidence in the trash bags. And you heard Marla Gray, the DNA expert, talk about the mixture DNA on some pillows that were found in the shed. And you also heard her say that that could even be from the person who made them in the factory. Or it could be from the person who touched the pillow at Walmart when they were trying to decide if they were going to buy it. It wasn't even enough DNA to test. So don't be led to believe that because of that, there's some unknown stranger who did these things. Look at the evidence. Look at the evidence that's in front of you. We have evidence. We have shown you the evidence. Don't think about the speculation. Don't think about the what ifs. Look at the evidence. Some really, really good. If I could, can I see the trash can for just a second, please? Thank you. Whose fingerprints were on the trash can? Do you remember what Agent Hoover said from the TBI yesterday? Where he's removed the rim. He talked about how it's smooth under the rim. If you're going to carry a trash can, how do you pick it up to carry it? Under the rim. Whose fingerprints were under that rim? Megan Boswell. Megan Boswell's fingerprints were under that rim. If we look at Exhibit 17, can you see the black trash bag there? Whose fingerprints are on that trash bag? Megan Boswell's fingerprints. And you heard Dr. Malushnik say, and I think you can see for yourself, that trash bag's not just gently placed down into the trash can. It has been forcefully, and it's a hard image. It's a very difficult image to think about. But that's the evidence that we've been left with, that black trash bag was placed on top of Evelyn in the white trash bag. And it was forcefully pushed down. Compressed, I think is a word that was used during the trial. And that's how Megan Boswell's fingerprints ended up on that black trash bag. Even more damning than that is the fact that Megan Boswell's fingerprints are on the foil wrapped around Evelyn's head. I would love to know a different explanation for how Megan Boswell's fingerprints got on that foil, on that trash can, on the black trash bag, except for the fact that she murdered her baby. She put her in that trash can with food trash and debris, covered her body, essentially mummified her, and tossed her away, literally, with the trash. Mr. Scott would like for you to think that the doctor's testimony, just that they shouldn't be able to just decide things in a vacuum. He kept mentioning, well, what if the child's dead on a table? And I think we all know that is not how doctors operate. Doctors operate off of medical histories and any information they can get. And that's what both doctors did in this case. They took everything, her birth records, her pediatric records, the scene itself, before they came to their conclusion. They don't operate in a vacuum. I think those were the words that Dr. Malishnik used, is they do not operate in a vacuum. And they determined what? Both doctors agree that this was a violent homicide, and that Evelyn Boswell died from some sort of asphyxiation. So, suffocation, I guess, is the easiest way to say it. So, if it was not for, say, the position of her body upside down in the trash can, that could have killed her. We'll say it wasn't that. Then maybe it was the blanket that was pulled up over. Remember that? How it was tightly pulled up over her face. That could have been what it was. Or it could have been upside down in the trash can. Could have also been the trash bag that she was placed inside of, where she was unable to breathe. Could have been the foil that was wrapped around her head. Could have been the trash can itself. If you remember, the doctor testified that her face was compressed up against the side of the trash can. And her body was in a reverse S curve, to where her head was so far bent back into a reverse S because of how the defendant compressed her body down into the trash can. Forcefully compressed her body down into the trash can. Her head and neck were wrapped so tightly with foil that even when they removed the foil, you could still see the impression of the foil on her face. You could still see the trash can form still to her face. Quickly, I'm going to ask you to go to your verdict form page. And it's going to be probably at the very end of your packet. Page 50 is where it starts. So these verdict forms, I'm going to show you one example. Okay. So you'll see here, this is just for count one, and I'm just giving it as an example. We, the jury, find the defendant and mark the appropriate box. So if you go back in the jury room and you agree as a whole that Megan Boswell is guilty of first-degree murder, you do not need to consider anything below that. Those are what we call lesser-included offenses, and we're required by law to put those on the verdict form for you to consider. But if you unanimously agree that Megan Boswell is guilty of first-degree murder, you can check that box and move on. You are not required to go through every single one of those if you believe that she is guilty of what she's charged with in that count. And if you go through these, you will see that each count of the indictment is similar. There are lesser included offenses for each one of these. Again, I will ask you that if you can unanimously agree, you do not need to go any further on that verdict form. The state has to prove several elements for each charge, and those are also in your packet. Count 1 is premeditated first-degree murder, that the defendant unlawfully killed the victim, that the defendant acted intentionally, and that the killing was premeditated. The next page defines premeditation for you as an act that was done after the exercise of reflection and judgment. It means that the intent to kill must have been formed prior to the act itself. So that means essentially when Megan Boswell wrapped Evelyn in the blanket, and you think, well, maybe she didn't have premeditation then. She could have formed premeditation in the time where she applied the foil, or premeditation in the time that she put her in that trash bag, or premeditation in the time that she pushed the next trash bag on top of her body. Ladies and gentlemen, I submit to you, there's nothing about this case that is not premeditated. Count 2 and count 3 are what we call felony murder in the state of Tennessee. That's where we allege that a murder happened during a certain felony. And these felonies are aggravated child abuse and aggravated child neglect. Again, those go hand in hand with premeditated first-degree murder. We submit to you that not only did the defendant abuse the child, but that she neglected the child. And one of the perfect examples is how she left her in the trash can. That's neglect. Leaving her in the trash can, that's abuse. And it resulted in her death, which is felony murder. And we have to prove that the child was under the age of 8. There are many counts of false report. Page 29, I think, is where it starts. And it's counts, I believe, 7 through 17. The state must prove that the statement was made by the defendant, that it was made in response to a legitimate inquiry by law enforcement, and that it concerned a material fact about the incident within the officer's concern. And if you remember, the defendant herself admits more than once that what she told the police was not true. So I submit that the state has proven each of those counts. Count 19, abuse of a corpse, page 30. The state must prove that the defendant mistreated a corpse in a manner offensive to the sensibilities of an ordinary person, that she acted without legal privilege and acted knowingly. And I think that count speaks for itself, along with count 20, which is failure to report a death. A lot about this case really has been more about Megan Boswell than about this child, Evelyn. But Evelyn mattered. She deserved to grow up. She deserved that, but her mom took that away from her. And there's no evidence that anyone else was involved. I think you can see this was a pretty good investigation. It was very thorough, and the evidence continued to point in only one direction. The evidence only pointed at one person, Megan Boswell. She failed her daughter. She had the chance to keep her safe, to protect her, to give her to someone else if she couldn't handle her. You heard from the witnessing, there were people that she could have given Evelyn to that would have given her a beautiful life. But instead, she violently murdered her daughter. And she told story after story after story for 2.5 months. And maybe the worst part is that she just went on with her life as if Evelyn had never even existed. But Evelyn did exist. Evelyn is a real person. And Megan Boswell should not be able to go on as if Evelyn did not exist. There are things we will never know about what happened. None of us will ever know everything. I think it's fair to say that we do know that Evelyn was in the way. She was in the way of Megan Boswell living the life that she thought she deserved, that she wanted to live. So Megan removed her. It's as simple as that. So today, 5 years later, almost 5 years to the day that Evelyn was reported missing, we are going to ask that you hold Megan Boswell accountable for what she did for her child. I submit to you, the state has proven every count and every element of every count beyond reasonable doubt. And we are going to ask that you return a verdict of guilty.
Thank you, General. Mr. Scott, you may close.
Good afternoon. I appreciate y'all's time. Appreciate you being here. Although I know you may not be here by your own free will, but I still appreciate it. This is a hard case. There's a lot of emotion in this case. And Amber Massengill is very good at giving an emotional closing and wanting you to play on your emotions. The jury instructions will tell you that this case is not about your emotion. It's not about sympathy. It's not about anything else. It's about proof and what's in the evidence. That's what this case is about. This case is more about what Megan Boswell didn't do than what she did do. Now, I'll go back through the witnesses here with you in a minute. But the state seems to be putting forth a theory that you should convict her of first-degree murder because she didn't grieve appropriately. She had fun after her child died. Now, is it far-fetched to believe that the child died in the first part of December, like she says? No, that seems to be the point where you see Megan's personality start to change. But I would suggest to you that change occurs when the child dies. You start to hear various friends come in and they talk. I can name them for you. Let's talk about Casey Saltz. She worked at Megan's pediatrician. And she was also technically would have been Megan's foster sister, I guess. She was the daughter of Megan's foster mother. And she talked about Megan being a good mother. She acknowledged that. She witnessed that. Megan brought her to the doctor. You have an exhibit in the records. It's item 67. It came in through the pediatrician. Read that page for page. It demonstrates that Megan was a good mother to Evelyn. She took her to the doctor for well checks. She took her to the doctor when she was sick. She got medicine for her. She did what she should do. And then she misses that appointment in December. And that's when this starts. And I would submit to you, when all of this really starts, the child is dead. Now, we hear from other witnesses. We hear from Paul Miller. That is Ethan Perry's grandfather. He had no reason to believe that she wasn't a good mother. Seemed like she liked being a mom. Saw no signs of abuse or neglect. We heard from Audrey Gibbs. She'd been with Megan almost every day up until she moved to Knoxville in 2019. She describes Megan as a good mom. There were a few things. There was once where she thought her diaper needed to be changed. Once where they neglected to buckle the car seat. But those are mistakes. That's not child neglect. That's not child abuse. Those are mistakes. Audrey talks about Megan coming to Knoxville up into December sometime, and by that point she acts disassociated. She's not normal. She's saying "I love you" over and over again to her. So, again, maybe she's not grieving right. Bailey Hawkins. Stayed at the Econo Lodge with Megan. Megan just went to sleep, despite Bailey thought they might do things, they might talk or whatever they might do. But she just went to sleep. Again, I would suggest to you she's disassociated. Bailey saw no signs of abuse, no signs of neglect. Mr. Horn questioned her. She described Evelyn as the one consistent love that Megan had. And Megan is a girl who comes from a world of fractured relationships. And Miss Massengill wants to downplay Megan's home life. Matt Price did. There's a video in there. He talks about it. He talks about, I mean no disrespect, but I know that Boswell family. I'm aware of them. I know how you come up. Your mom and daddy using drugs. I mean, you want to talk about a home life, watch the video with Agent Fraley. Her mom was laid in there in stripes, a jail uniform. What kind of home life was that? Then we get to Caitlin Jones Carter, whom you can make what you want of her testimony. Her body language tells me she's no longer Megan's friend. However, she described, aside from the one day when she saw Evelyn as dirty, that Megan had been a good mother. No signs of abuse, no signs of neglect. She said she saw Evelyn sometime in December. She tried to tie it to her school, but she really couldn't give us a specific date. So I think the best you can say is that it's sometime in December. Gail Kite. Let's talk about her. Megan's foster mom. She gets Megan when Megan comes into her foster care. Megan's 7 months pregnant. She's 17 years old. Gail describes her as looking like she's not pregnant, as being underweight. We know from the medical records and the testimony that come in from Dr. Smith, Megan suffered from intrauterine growth restriction at that time. We've heard that. So that's the shape she's in. But Gail talks about how she gets her in good shape. She has the baby. She's a loving mother. She takes care of the baby. Gail never saw abuse, never saw neglect, never had any doubts about Megan. Erica Stacy, and that's the mother of Megan's ex-boyfriend, and I think his name was, I can't remember his name honestly. That's the mother of his ex-boyfriend. She described Megan as a good mother. Evelyn was always clean. And I'll point something out to you. The state wants you to believe that Megan just meets Hunter Wood and throws this child away for him. She didn't do that for, I think it's Caleb Stacy. She didn't do that for Caleb. There were other boyfriends. Now there's talk about, a lot of talk about Ethan Perry thinking he was the father. Well, the proof you've actually seen is they go about as Ethan is the father. And there's been no proof that Megan knew that he wasn't the father at that point. I'm not trying to, I mean, it just happens that sometimes people may think one person's the father and they're not. But calling him out on anything or anything else. Like, it's not like this didn't start early on that she thought Ethan was the father. She obviously thought a lot of Ethan. She drove to Texas, took Evelyn to see him. Now, he did say one thing that kind of struck me a little odd. He acted as though she just showed up in Texas. I suspect, and he finally admitted on cross-examination, that he told her where he was in Texas. You just don't hop in the car and drive to Texas and say, I'll drive around El Paso till I see his car in the parking lot and pull in. That's not what happened. I think he kind of wanted you to think that, but that's not what happened. Let's talk about Randy Wood. Randy Wood is the father of Hunter Wood. The state called him. The state is the one who elicited the information about Hunterwood being hospitalized. That's the first you hear of him being hospitalized. It's the state. Now, Ms. Massengill wants you to think I have some grand conspiracy theory. I don't. I do have a statement from Megan Boswell when she talks to Agent Fraley about what happened in this case. She says, Hunter was there when Evelyn died. I wrapped her up and I swaddled her. I held her. She kept getting colder as the day went on. I didn't want her to get cold. Hunter took her and he got rid of her. Now, they want you to believe that that's just impossible. Why did Hunter not give his DNA? Ask yourself that. If you have nothing to hide, why wouldn't you just let them test your DNA against all the evidence they had? Turns out they couldn't have tested it, probably. But he didn't give them that chance because he had something to hide. Now, his dad said that he was schizophrenic. I asked him, is he schizophrenic and have hallucinations? He agreed with me on that. He also agreed with me when I asked him if he talked about using an aluminum foil or tin foil. And he said, yeah, he talks about some off-the-wall stuff. Now, ask yourself, who's more likely to wrap that child in tinfoil? The child's mother that has cared for the child, taken care of the child, or the boyfriend who's schizophrenic? And I'm not trying to vilify Hunter Wood. That's not been my intention throughout this trial. But Megan's statement is that one of them rolled over on the bed. And the young mother may think that. There could have been other causes. When we get to the causes, I guess we can go ahead and we can talk about Dr. Schmidt and Dr. Malushnik. Now, Dr. Schmidt asked her about several different things. She's the lady who actually performed the autopsy. And she formed an opinion of homicidal death based on the way the child was in the trash can. But she could not tell you a medical basis for the child's death, other than a diagnosis of exclusion. And a diagnosis of exclusion is simply, we don't know what else is wrong with her, so she must have smothered in this trash can. That's what they want, what she said, essentially. Now, I cross-examined her about a lot of things. I asked her about SIDS. And even though the subsequent doctor didn't agree with it, Dr. Malushnik, I didn't ask about something that didn't exist. Dr. Schmidt knew exactly what SIDS was. We talked about it. We talked about the ages, how we don't know what causes it. She answered questions about it. She said, ultimately, she could not rule that out in this case. Just like she could not say with any degree of certainty that the child was placed in the trash can alive and dead. She couldn't say that. She brought up that the child had a heart valve that leaked. She admitted under cross-examination that that could have been what killed the child. We talked about laryngeal, we talked about laryngeal convulsions. Could that have caused the death of the child? She admitted it could. Now, Ms. Massengill brought up that I brought up tongue tie. I brought up GERD. I brought up an infection she had because all of those things can lead to the onset of SIDS. That's the research, and Dr. Schmidt agreed with that. Now, I want to tell you something about Dr. Schmidt and Dr. Malushnik. I think Dr. Schmidt she was the medical examiner in Johnson City when this happened. Dr. Malushnik is not her boss. She's not, it's not like she's somehow over her. Dr. Schmidt was the chief medical examiner at the Jenkins Autopsy Center, Forensic Center. Subsequently, for whatever reason, the state sent her report to Dr. Malushnik for another opinion. Dr. Malusic only reviewed her report, and she finds that it's a good report. But then she wants to go further and find with some type of certainty that child was placed in the trash can. And you saw an exchange between me and her in here yesterday. It went on for 4 or 5 questions. And I kept asking her, Doctor, can you say any type of certainty? What can you say about this? Can you conclusively say that child was dead when it was wrapped in the blanket, wrapped in tinfoil, and put in the trash can? She evaded that question. She wouldn't answer that question. She finally answered that question only after it was threatened she would be in contempt if she didn't directly answer the question. And her answer was, no, I can't say conclusively. And then she threw out kind of a parting shot at me as she left. And suggest to you the more accuracy of that parting shot, she said the child could have been murdered some other way. Should have been. The child could have died some other unknown way. That's what the truth would have been. She presupposed that this child was alive when it went in the trash can. The doctor who did the autopsy was very clear she could not conclude that. She said it couldn't be excluded, but it cannot be included. Dr. McLustick come in with a preconceived notion of that's what happened. Now, the state has to prove to you cause of death in this case. They have to prove that child was unlawfully killed. They have to prove this wasn't an accident. The proof from Dr. Smith leaves open a heart, it leaves open SIDS, laryngeal convulsion. It leaves open all of those things. We don't know what happened. And he also left open a rollover, which is what Megan told Agent Fraley. And now, would Megan know for sure that that's what happened? Maybe not. You wake up and you find your baby dead in bed. Could you not come to the reasonable conclusion one of us must have rolled over on it? She's 17 years old. She's not sophisticated. She's had a hard life. She's scared that she's going to get in trouble. Hunter Wood's scared that he's going to get in trouble. And that's why she does what she does. Hunter takes the baby to dispose of it. She knows about it. Is that right on her part? No, it's not. Should she have called and reported it? She absolutely should have. I told you that in my opening statement. Have they proved that she's a liar over and over? They have. Don't deny that. They haven't proved she's a murderer. You have more counts of false report than I can really count. I think there's 11 or 12 of them. Almost every time she's talking to law enforcement, you're considering a count of false report. With the exception of, you're not considering one for the time she talked to Agent Fraley. That's not before you. I would submit to you what happened was the conversation with Agent Fraley on the 25th of February, almost 5 years ago. That was a breaking point. That's a breaking point where she finally admits Evelyn is dead. She's able to admit to herself. You saw all these pictures she's sending back and forth before that. That's how she's grieving. Maybe she doesn't want to accept that the child is dead. Maybe as long as she keeps talking about it, talking to the media, talking to the police, and saying that Evelyn is somewhere else, she believes that. Maybe that's how she's getting by. You can't judge someone for how they grieve. You don't know what goes through their head. You don't know what they were raised with. I've never lost a child. I hope none of you ever have. But how am I to tell someone when they lose their child how they grieve? How am I to do that? Amber can tell you that. Oh, she shouldn't have went here. She shouldn't have did that. How does she know that? She's not in Megan's shoes. She's not out there living in that single wide trailer. That's not her life. She's not been raised by drug addict parents, a dad that beats on her mom constantly, and seen that growing up. She's not seen that. She can't put herself in her shoes. It's not fair to say she murdered her child because she didn't grieve right. I resent it. You should too. You should look to the evidence in this case. Do they prove a cause of death? That's the stopping point on the homicide counts. They can't do it. They brought two medical examiners in here who contradicted each other. The first one at least had read her medical records. The second one talks about how she is perfectly a healthy child. She ignored everything in her medical records. She didn't talk about them. It was obvious to me. Should have been obvious to you. She hadn't read them. She didn't care. It was her job to come here and convict Megan Boswell of murder. If you don't believe that, why would she leave here and say, well, she must have been murdered some other way? She was a biased witness, and she wasn't a credible witness. Now, let's talk about the tinfoil. How can her one fingerprint be on a piece of tinfoil? You all see this roll? Maybe like this. Okay, my fingerprint's on this roll. I've taken this one. The next person who gets this is going to get a piece of tinfoil with my fingerprint. That's a possible way. What's another possible way? We've heard that the tinfoil had food and debris on it. So there's food and debris in the trash can. But maybe the tinfoil was already thrown away in the trash can. If it came off of a roll like that, whoever got it would have had to have reached in there and gotten several pieces. There were several pieces of tinfoil. I believe 4. There should have been fingerprints all over it. One fingerprint. One fingerprint. It doesn't prove she put that tinfoil on there. Now, what about DNA on the garbage can? I would just about guarantee you, each and every one of you, your DNA is on your garbage can in your kitchen. Your DNA is all over the house. Your finger, I said DNA, actually it's fingerprint. Your fingerprints are all over your house. It's the kind of thing we don't think about, but you touch something, you put your prints. I think that's what you should consider. I mean, probably Evelyn's handprint on the trash can. At some point, I think in opening, I mentioned to you an unidentified palm print on the trash can. Well, I didn't know at the time it was a child's because it wasn't in the fingerprint analysis report. It's not unbelievable that it's the child's. Now, Ms. Maxengill made a statement. I was a little perplexed with it. The state wants you, or the defense wants you to believe that wearing gloves prevents putting fingerprints on something. You heard the fingerprint experts say they can. I think we all know that from our common sense stuff. If you cover the fingerprint up, you're not going to leave it on something. Now, let's go back to the statement with Agent Fraley. February the 25th. She's talked to law enforcement over and over. And she talks about how she breaks down. She breaks. It's the breaking point. She admits she's dead. And she's telling them the truth. How do you know she's telling them the truth? Because if she's still trying to lie to them, if she's still trying to confuse them, she wouldn't have said, I don't know where the baby is. It could be at Hunter's. It could be at Tommy's. Why would you say, if you're trying to lie to them, perpetuate this lie like Miss Massagill tells you, that the baby could be at Tommy's? Why would you do that? Ask yourself that question. She's telling them where the baby is. She thinks, I think it could have been left one of these two places because I want to find it. And you'll have that video. You can watch it as many times as you want to. I hope you will watch it again. You hear Agent Fraley talk about how he'll go to the DA. She's a scared young mother. He understands that. Now, I don't have to prove this case. I wish I could, but I can't. You can't prove a negative. What I can tell you is the state has not proven their case. They've not proven the cause of death. They've not proven that the death was an unlawful killing as opposed to an accident, or some rolling over in the bed being an accident, or some kind of health-related issue. They haven't proved that. Let's talk about the gloves. I go around in circles sometimes, and I hope y'all are following me. I apologize for that. But let's talk about those gloves. Ms. Massagill talks about the criminal tore the gloves up in the trash can. I think if you'll remember back and look to your notes, TBI cut those gloves up for testing. I could be wrong, but I think that's the case. Now, what do those gloves tell us? Do they match up to anyone? No. But they do match up to an unknown male. There's not enough profile there to match it to someone specifically identify them, but it matches it up to an unknown male. That's why there's not multiple fingerprints on the tinfoil on the child. Those gloves that match some unknown male. We know it's male DNA. We know that. Finally, let me talk just a little bit about Hunter. There's a text thread, and it's in February. It's between Megan and Hunter. And it appears like Megan's telling Hunter the same story she's telling everyone else. But remember, Megan's told Agent Fraley that Hunter doesn't want his name brought into this. He doesn't want to be involved. He told her not to tell anybody anything about the child. At this point, Hunter, he throws out a name in that text. He talks about Agent Wilhoit. He's been involved with the police. He knows the police are looking at this. This is February the 22nd. Suggest to you that text thread is, look at the texts. They're self-serving. I'm just worried about the baby. I just want the baby returned safe. That's Hunter and Megan's way of covering Hunter's involvement in this. I'm not saying Hunter killed that child. I'm saying he did dispose of the child. That text thread, it's a convenient way if you think about it. If you're trying to have proof that you didn't do something, if you start a conversation, start texting it, say, oh no, I didn't do that. Look at my text. I texted her, she's told me this. It's a convenient thing for me. But he didn't give his DNA. We know that. His dad talks about he went crazy because he was called a baby killer. Maybe he went crazy because of his participation in disposing of that body. We don't know. Everybody seems to agree he has went crazy. You saw a document admitted this morning. That's where he's being held out of court over in Virginia to be evaluated to see where he's competent for some crime he's committed. He's up at Marion right now to be evaluated. That's what we know. I hope I've answered your question. I hope my argument has helped you somehow with this case. But what I would say to you, if you have questions about any elements of these crimes, and your questions are not answered to your satisfaction, you have reasonable doubt. If you say, I don't know how that child died, that's reasonable doubt on the homicide. I don't think I have much more to say to you. I go to a Baptist church and I hate long sermons. I'm used to it. I think I've been up here for about a half an hour, but I thank you. I pray you'll come to the right decision. Thank you.
Thank you, Mr. Scott. General, you may close on behalf of the state.
Thank you, Judge. Ladies and gentlemen, much like Megan Boswell, Mr. Scott seems to have some very convenient explanations for what happened in this case. Lots of things that happened in this case. All of the evidence in this case that points to his client, he's got some sort of explanation for it. But the problem is, in order to buy into this, in order to believe it, you have to believe Megan Boswell. You have to believe that when she spoke to Agent Fraley on the 25th, that she was somehow, for the first and only time in this courtroom, speaking the truth. But I think each of you, as you sit here, know that's not possible. That's not possible. Megan Boswell is one of those people. You used to hear the expression, the truth ain't in them. The truth's not in Megan Boswell. She doesn't know how to tell the truth. Everything that she tells to every person in her life is for some reason. And that reason is because Megan's trying to get something out of it. She is a master manipulator. Even at 17 years old, you sit there and watch those videos. She's trying to play everybody. She's trying to play the law enforcement officers who are interviewing her. She's playing her friends, every person in her life who walked through that gate and sat up on that witness chair was in some way manipulated by Megan Boswell. Some way. Whether it was about Evelyn, whether it was about how she was going to pay for a babysitter, whether you're the father of my child, whether you're a great-grandfather, whether your wife who's dying of cancer is babysitting the kid. I mean, she knows no bounds. There is no person that she will not manipulate and tell untruths about and to. No one. But Mr. Scott comes in here today and says, yeah, hey, come on, ladies and gentlemen, the 25th, you could that was the point, which she decided, hey, I'm going to be truthful here. No, it wasn't. And we know it's not. It was just another story. She was telling law enforcement to lead them some other way. That's all it was. And if you remember, Agent Gratz testified. General Massengill was asking him the question, when did this first thing about accidents and rollovers, when did that come up? Well, it came up when the police and law enforcement finally said, yeah, we got nothing going on here. We got to give her an out. We got to give her something so we can try to find this kid. So they're the ones who suggested it. And then very conveniently, the next day, she comes in, and guess what? Oh, yeah, I forgot. Yeah, that's right. I'm sorry I've been lying to you all for days and days and days now. But now I'm going to tell you the truth. But that's not what happened. That's not what happened. I submit to you, the only time Megan Boswell may have told the truth about some small portion. If you remember during one of the interviews, Lieutenant Price, who had been very patient with her up until that point in time, finally said, come on, something happened on December 21st. And she stopped him and corrected him. Remember? She said, no, something happened before December 21st. Yeah, something did. She murdered her child. That's what happened before December 21st. Ladies and gentlemen, before I speak further about the physical evidence that ties and shows that Miss Boswell is the one who is guilty in this case and who needs to be held accountable, I want to take you back to jury selection. Last week when you all were first up here and up there, and I asked you if all of you had brought your common sense with you. And if all of you, as you listen to the evidence in the case, would use your common sense. And everyone agreed that you would. And so I want to remind you of that. And it reminds you to apply that to the evidence that you've heard, the testimony that you've heard in this case. Because the defense wants to say that perhaps, again, speculating, it's a possibility that Evelyn just died one day in early December. And then all of a sudden, Megan engages in this pattern of just totally bizarre behavior that involves wrapping her child in a blanket, tightly pressing her head in aluminum foil and stuffing her in a trash can, and then engaging in this just convoluted tale to anybody who wants to inquire about what's going on with Evelyn. But it's a remarkable coincidence, isn't it, that all this occurs at the same time that she starts working at the chicken shack, and that she meets Hunter Wood. You know, that Hunter Wood, the one who lives out on the lake in the big house. And remember, this is where Megan's living before December. These are the conditions Megan's subjecting her child to before December. Then she meets Hunter Wood. Big house out by the lake. Dad owns a business that I'm working at. Remember the other things she's telling investigators as time goes on. Needed a break. Watching 3 kids. Remember, her mom had the 2 other young siblings. Needed a break. Was tired. Wanted Ethan Perry step up. I've been raising this kid for a whole year by myself. Probably a little bit of truth in there. A little bit of truth. But it's a remarkable coincidence. This kid, Evelyn, natural causes, just dies right at the same time. Apply your common sense in asking yourselves why. Why would Megan Boswell then start on December the 7th? She tells Bailey Hawkins, hey, it's just me. Ethan's grandma has Evelyn right now. December 7th. Remember, she starts Chicken Shack the 2nd. 7th, 5 days. 5 days later. Why does she start telling all these things that are obviously not true? I'm in a custody battle with Ethan. I don't have it. Evelyn's sick. She's got the flu. I can't bring her. Can't bring her up there to get the Christmas gifts. Let you see her. Why does she do that? Why does a mom who, by everybody's testimony, everybody's, her friend Bailey Hawkins told you, I mean, yeah, she wasn't a perfect mom, but she did well. She did well. They all did. I mean, she's posting pictures on Facebook, Instagram. Everybody. Her own pediatrician, Dr. Pugh, came in here. Yeah. She's a good kid. We didn't have any concerns. Healthy, meeting milestones, an advanced child. Why does a mom who dotes over her kid, who won't even let anybody babysit, she's so protective of this child? Remember Erica Stacy? I mean, heaven's sakes. I mean, an ex-boyfriend's mom who is willing to babysit the kid so that her son can go on dates with her, she won't let her do it. She won't let her do it. She will not let her babysit. That's how protective she is of this child. So why? Why? Apply your common sense. She won't do it because she can't face the truth about what she's done. She can't face that truth. She can't look at that picture. And I'm not going to put it back up there for you. She can't face what she's done to that child. Discarding her like a piece of garbage. That's what she did. She can't face that truth. So she engages in just spinning all these stories to everybody. Everybody that comes with a story, she's deflecting it out because she doesn't want to face that. It is almost unbelievable to me that the defense is still arguing that Hunter Wood had some involvement in this case. I mean, truly unbelievable to me that they're making that argument. That has no credibility, number one. And two, no proof whatsoever. Not a single shred of evidence has been presented in this courtroom that ties Hunter Wood to anything dealing with the death of Evelyn Boswell. Not one thing. It's all just rank speculation. Oh, well, because he's in a mental hospital, therefore he must have done something. Right? No. How many people walked up there, took that witness stand and said, oh, yeah, I remember when I saw Hunter and Evelyn and Megan together. I remember when I saw that. None. Nobody said that. How many people said, oh, yeah, I remember when I saw Hunter holding Evelyn at the chicken? No. Again, nobody said that. No evidence, nothing from that witness stand ever put Hunter with Evelyn. She evidently wants you to believe, again, and I'll put this picture back up there. She wants you to believe that Hunter, and remember her when she's talking to Agent Fraley, that Hunter went over to her place. That's her place. Stayed the night with her and rolled over on the child. He's got a place over, nice place over on the lake, remember. But that's what she wants you to believe. When her breaking point, when she's finally telling the truth. Apply your common sense to that. What else possibly ties Hunter to this case? To Evelyn's body being disposed. Well, maybe it's the playhouse over on Tommy's property. No. Again, we know Evelyn is probably gone 5 days after she first met Hunter from working at the chicken shack. But Megan Boswell wants you to believe that he's been able to go onto her property and stick a body in a trash can in a playhouse that was built for Megan Boswell. Mr. Scott asked you, and I wrote it down. He asked you who was more likely to have left a print on the foil. Well, I'll tell you who's more likely to have left a print on the foil. The person whose print was found on the foil. Megan Boswell. He stands up here, and again, we've got explanations for everything. Well, maybe it was possible she tore a sheet off earlier, and in doing that, she grabbed the foil and left a print. Well, there's no Hunter Wood prints on any of the foil. The bag that's stuffed on top of the body where Evelyn's found. Multiple prints on that. None of them belong to Hunter. They all belong to Megan Boswell. He wants to say, and again, it's still beyond my comprehension that we're talking about Hunter Wood here. You know, why wouldn't Hunter give a DNA sample? I don't know. Perhaps because Hunter is being mucked up in Megan's world here. My gosh. Here I am dating this girl, and all of a sudden I got TBI agents asking me about a child that's missing and no explanation for it. Maybe that's why. And again, in this particular case, you heard from Agent Gray. What does it matter? There's nothing that was tested. All those things she testified to yesterday, all of them, all those things I handed up to her, that she analyzed, not one piece of them had any identifiable DNA on it that could have been tied back to Hunter. None. Everything was Megan's or Evelyn's or limited profiles. As I remember, I asked her if I gave everybody in the world's DNA to her, she wouldn't have been able to match any DNA to Hunter Wood. Nothing. Nothing. Everything connected to that body in the trash can comes back to Megan Boswell. And then, let's not forget, in the middle, while all this is going on, February 22nd, Megan's child's missing. They questioned Hunter. And they had this conversation. And Mr. Scott wants you to believe that this is some kind of contrived thing between Megan and Hunter. But what evidence did you hear that there was any sort of contrived conversations going on here? Nothing. Again, nothing. In order to believe that, you've got to believe one person, Megan Boswell. And we know you can't believe her. No. Hunter says, yeah, but where's the baby? I just want the baby to be found safely. What's her response? If she was truly trying to cover this up, a little bit better response would probably be heard. She says, Dad won't let me go anywhere because of the situation. Hunter, I can't disclose stuff to you on here about what TBI is doing. His concern, please assure me the baby will be found and brought home safely. That's not a conversation with someone that you have that has disposed of a body, that has helped get rid of your dead child. That's not a conversation. Hunter Wood is not at play here, ladies and gentlemen. Not at all. Not at all. Defense has also talked to you about these things medical conditions that they questioned the medical examiners about yesterday. Possible things that might have caused Evelyn to just suddenly die of natural causes. A perfectly healthy child. Again, he's asking you to speculate about possibilities. But we don't decide this case on possibilities. And if you think about it, ladies and gentlemen, you didn't hear from just two doctors about Evelyn's condition, about what kind of a child she was. You heard from three doctors. Her pediatrician testified in this case too. And what did she tell you? Evelyn was a healthy child, advanced, had met all of her milestones. Any concerns about her health? No, her concern was that on December the 5th, she doesn't show up for her year checkup appointment. She's a no-show. That's her concern, not Evelyn's got tongue-tied. I'm concerned maybe she's going to die from SIDS. Not, oh, she's got some sort of reflux going on. I'm afraid she might be at risk to just suddenly die one day. That's not her concern. And remember, and Mr. Scott didn't talk about this because you don't want to talk about it. I asked Dr. Malushnik yesterday about statistics. This wasn't just her opinion. These are statistics kept by the Department of Health in Tennessee about the number of kids over 1 year of age who died in rollover deaths. Entire state of Tennessee last year, none. Entire state of Tennessee last 10 years, none. But yet, they want you to believe that's a possibility in this case. She's the first one, ladies and gentlemen, evidently, the first one. No, it's not a possibility. You're to decide this case on the evidence that you've heard and the testimony you've heard from that witness stand. And the testimony you heard from 2 different medical examiners said this child died from asphyxiation. That's what they told you. Both of them told you that. He said they had contrary opinions. They didn't have contrary opinions. One of them had a little stronger opinion, but they both had the same opinion. They both told you the cause of death was the same thing, asphyxia. And all the evidence in this case points to one person alone as being the person who caused that asphyxiation. And that is Megan Boswell. This wasn't an accident, ladies and gentlemen. It wasn't an accident at all. You've got lots of evidence of premeditation sitting over there in that box. This isn't a little piece of tin foil. This isn't foil like you stick around a baked potato and stick in the oven. You saw it. You saw the photographs, and the foil's in there. Pull it out. It's a big old piece of foil. Mr. Scott wants to suggest maybe it was sitting down in the trash can. Somebody pulled it out. Nobody's using that much foil. Use your common sense. And remember the testimony from Dr. Malusnik yesterday about how that foil was applied. That blanket, so tight when they're taking it off, the impressions left on that child's face. The foil, how painstakingly slow they had to pull it off because it was tightly compressed around the child's head. I submit to you, that's premeditation, ladies and gentlemen. That's intent. That's not an accident. Part of this case, ladies and gentlemen, that Mr. Scott said is really, sad. It really is. It's a tragedy. You think about all those people that you heard testify, how easily all of this could have been avoided. All those people, Bailey Hawkins, Audrey Gibbs, Casey Saltz, Gail Kite, Paul Miller, Erica Stacy. Any one of those people would have taken that child. All this could have been avoided. But Megan Boswell only cares about one person, and that's Megan Boswell. She started a facade back first week of December after she killed her child. She created this world, this web, you've heard it called. That's a pretty good description of it. It's a web. It traps and ensnares everybody that she comes into contact with. She started this facade back then, and it's continued and continued and continued. And she brought it into here to this courtroom in front of you. And she's trying to get you all to believe the rollover, believe the accident, believe my child died of natural causes, and that I just flipped out and engaged in this totally bizarre behavior. But in order to do that, you have to ignore the evidence in this case. You have to ignore the forensics that place her and her alone as the perpetrator of this crime. This case is the very opposite of an accident. It's an intentional and knowing murder of a child. Megan Boswell got rid of Evelyn so that Megan could be Megan. She enjoyed it. You've seen the pictures General Massengill showed you. Hanging out on Blowing Rock, going to the aquarium, Super Bowl party. Megan Boswell sits here in this courtroom today as guilty as she was back in that first week in December. As guilty as she was on February the 18th, when she first came in there to take the Perez, the James Lewis interview. She acted all surprised. What are y'all going to do? You going to find my child for? What do you do when a child goes missing? Remember those expressions, those questions she threw out there? She sits here in this courtroom today as guilty as she was back then because she never learned the one lesson that we all know, which is that you're responsible for your actions and your choices in life. And she sits here because she refused to learn that lesson. You've heard her interviews. She takes responsibility for nothing. But today is the day that you get to hold her responsible for those actions, for her poor choices and decisions, for her decision to get rid of Evelyn, to dispose of her like a piece of garbage. That's what she did, ladies and gentlemen. She disposed of her child like a piece of garbage. But her poor choices and decisions have a price, and they have a consequence. The state has proven to you over the course of the last week, Megan Boswell was guilty, first-degree murder, false report, tampering with evidence, and failing to report that death to authorities. We ask today that you hold her responsible for those poor decisions by finding her guilty as charged.
Thank you, John. Let us see the attorneys.
Okay, maybe some final jury instructions and then done. Dun, dun, dun. That was 27 minutes. Yeah, a bit longer than I would liked it to go on for, but there we go. He said there might be some more instructions, so I don't know. Maybe the forms.
Mr. Hyatt, Mr. Selner, Mr. Arnett, you're the three alternates. If you will go with the officer,
This is what he meant. Extra instructions, as in
just leave them in the
alternates.
seat. That'd be
Okay.
fine. And your notes as well. We'll just take care of them.
There we go. He hadn't done this bit, is what he meant then. Good. Good.
The rest, what do you mean? Yeah, I'm going to finish the charge. All right.
Oh, no, he's got more.
Now, back on page 49. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will deliver the verdict form to the court. Take with you the presentment, the exhibits, the verdict forms, the court's written instructions, and you may retire and consider your verdict as soon as the officer comes back to get you.
Okay, that's all it was. Woof. Woof. That's all right then. That's all right then. Then they start deliberations. Whoa, 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 whoa. What do people think in the chat here then? 81% think guilty of murder 1, 8% think guilty of murder 2, and 12% think guilty of manslaughter. How long? I don't know. This is such a complex one because the instructions are so confusing, the charges.
One please.
305 p.m.
I think there's some people have already made their minds up, but some may not. I think they've all made their minds up about the murder, but at what stage? 1 or 2, I think, maybe. Was it premeditated or not? That might be
We're in
discussion.
recess, waiting verdict of the jury.
And also, it's the little tiny fucking charges, you know, we just don't know. So, look, I thought the Alex Murdoch case would take like days. It took 45 minutes. And then there's some trials I thought this will take like, you know, days, and they come back in 2 hours. So my only concern is that as Rhode Island says, just too many charges. It'll get confusing in the end. Because you can remember, these people don't know what any of that means. So it's going to be hard. But good luck to them. So it's 20:08 for me, which is 3:08 Eastern time. So 3:08. So deliberations. Hang on. Deliberations began at 3:08 p.m. Eastern. I'll put verdict watch. Verdict watch for Megan Boswell. Okay. A little face, I know, yeah. Karen's jury couldn't handle 3. Well, I think, to be fair to some of them, I think Judge Bev fucked that one up for them as well. But I think the main thing with juries are, well, you can remember, like at least we watch trials. I can guarantee most of them have never seen a trial before in their lives. So they have no idea what's going on, what they should be thinking and stuff. So I think it's a tough job for them in that sense. Because why do they fucking complicate it? You know, I don't understand any court why they complicate it. Make it as easy as possible for people. Right, we're gonna watch. We're gonna watch Erin Hack. Hang on, let me try something here. You know where we're going now. I just need to find where I'm going. We'll be there. I have to play that there, put this in here, put that there, put that there, put that there. That will be there, that'll be in the background, and then what I'll do next is put that there, and then right, we're going to be watching Colin Gray. Let me put Colin Gray there. All right, Erin Hack better be here because she loves this sort of thing. Is she here?
Erin Hack, she drives a bus, yellow bus, yellow bus. Erin Hack, she drives a bus all day long. Ole, 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 ole. Erin Hack, 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 ole. Erin Hack, 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 ole. Let's go, Erin Hack, 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 ole. Erin Hack, 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 ole.
Here we go. Boost it for Deb. Put that up there. So this is Colin Gray, Georgia against Colin Gray, Georgia school shooting the father. So it's about an hour, 24 minutes for those who are interested. So we'll watch this now whilst we're waiting for Verdict Watch. I got the Verdict Watch app as well here next to me, so we'll see. All right, let's go, people.
Told you on May of 2023.
Judge, we're going to object this ask and answer. It's been 3 times. He's answered the question 3 times, and now we're getting into hearsay.
Let me ask you a question. In May of 2023, was there a home visit type defect where they told you there would be monthly home visits?
No, sir, not at that location.
Not at that location. What location did you have contact with defects?
I had contact with defects in my home recent here in Bethlehem. I received a phone call at 10:30 at night from.
Hang on then. That's out of sync. Hang on, let me refresh it then to see.
Home visit, they told you on May of 2023.
We're going to object this ask and answer. It's been 3 times. He's answered the question 3 times, and now we're getting into hearsay.
Let me ask you a question. In May of 2023, was there a home visit type defect where they told you there would be monthly home visits?
No, sir, not at that location.
Not at that location. What location did you have contact with defects?
I had contact with defects in my home recent here in Bethlehem. I received a phone call at 10:30 at night from a defects caseworker that gave.
Right, let's have a look, see if there's the stream for this one then. Because that is bad. Colin Gray. Bear with me, people. That is bad. You're my fire, my desire, Erin Hack, hack, hack. Right, I got another one here. Yeah, I got a better one here now, so good. You're my fire, my desire, Erin Hack, hack, hack. All right. Boost it for Deb.
How long had you lived at that address?
A little over, coming up on a year.
Where did you live previous to that?
I lived in Jefferson.
And what county is that in?
I believe that is Jackson County.
Okay. And to kind of cut to the chase, how long have you lived in Georgia?
My whole life.
Do you have family here in Georgia as well?
Yes, sir, I do.
And who would that be?
I have two sisters that live in Georgia. I have 5 children, and I have 4 granddaughters.
And when you say in Georgia, are any of those folks living in the metro Atlanta area?
Yes, sir, they are. My immediate family, 2 sisters that I just spoke about, they live in the metro area.
Okay. And prior to your arrest, were you employed?
I was, yes, sir.
And what were you employed as?
I was a general superintendent at Kevin Price Construction.
Okay. And how long did you have that job for?
It's coming up on 5 months, 5.5 months.
Okay. What about prior to that? Were you employed before that?
I was with Van Winkler Construction out of Atlanta,
What was your position with them?
project superintendent,
And how long did you have that job?
a little over a year.
Is that what you primarily been doing as an occupation?
Yes, sir, I've been doing it for 28 years.
And that job, does it require you to travel at all?
It does, and that's why I made the move from Van Winkle was the travel, and I recently come into being a single parent with all 3 of my kids, and travel was just not an option anymore, so change of jobs kept me close to home.
Okay. And have you ever been convicted of a felony before?
No, sir.
What about a misdemeanor?
No, sir.
What date, if you can recall, were you arrested?
I was arrested on September 5th,
And have you been in custody this whole time?
the whole time.
And you currently have no bond on any of your charges, is that correct?
What's that?
You currently have no bond on any of your charges.
No, sir.
If you were to be granted a bond by this court, and the court set certain conditions, would you abide by those conditions?
Absolutely.
Would you attend court hearings as ordered by the court?
Absolutely, yes, sir.
And 1 second, Judge.
Yes, sir.
Thank you, Judge.
Mr. Gray, I have no further questions. The state probably has a couple questions for you, so just hang tight.
Okay. Prosecution.
You said earlier that you didn't have any prior misdemeanor convictions. Did you have an abandonment of a child in Cobb County in 1998? Is that you?
And that was my understanding at the time. It's been such a long time ago that was overturned because I produced the proper documentation.
At that time, you were living in Cobb County,
I was in Cobb County.
and then you had a conviction for possession of marijuana in Paulding County in 1999.
In 99, yeah, that's kind of a long time ago.
Yeah.
I'm not sure about that.
Were you living in Paulding County at that time?
No, sir, I believe I was living in Cherokee County, possibly.
Cherokee County.
Yes.
So 98, you were in Cobb County. 99, you were in Cherokee County.
Yes, sir.
I want to take you more immediate time frame.
Okay.
In 2017, 2018, you lived at 2439 Bear Creek Road in Statham, Georgia. Is that correct?
That's correct.
And at that time, Colt, your son, was enrolled at Statham Elementary School.
That's correct.
That was the 2017, 2018 school year.
Correct.
And in the next school year, 2019, did he transfer to White Sulphur Elementary School in Hall County?
In Hall County, yes, sir.
And y'all lived at 3208 Winterberry Lane, Gainesville? So that was just the very next year.
Yes, sir, we sold our property.
Okay, and then at some point, he ends up at Chattahoochee Elementary School in 2019, 2020, and that's in Forsyth County.
Correct.
Okay, where were you living at that time?
We had moved up to Lake Lanier, because we were considering building a house up there. So, that was, I need to think, I can't remember the exact address of that, but it was basically on the northern side of Lake Lanier.
Of the Cumming area?
Yes, sir.
Okay, so that's three houses, and 3 schools in 3 years?
Yes, sir.
Okay. And then in March of 2020, he transfers to Ben Hill Elementary School,
Yeah, correct.
and that you lived in at 139 10 Mile Road, Fitzgerald, Georgia.
Yes, sir.
Okay, so now we're at a 4th school in 3 years, a 4th residence. And in January of 2022, he transfers, I'm talking about Holt transfers to West Jackson Middle School.
Correct.
Okay. And at that time, did you live at 2975 Rice Creek Drive in Jefferson?
That's right.
Okay. And I have another address for you shortly thereafter, 2983 Rice Creek Drive in Jefferson. Is that mistaken?
Yes.
Okay. It was just the 2975 Rice Creek Drive, Jefferson. Okay. And then in September of that year, he transfers to Jefferson Middle School. Is that correct?
Yes, sir. I believe when we lived in Jefferson, it was just him and I. He did attend that school.
Okay. And you moved at that time to 954 River Mist Circle in Jefferson. Is that correct?
No, in Jefferson, it was just it was the only home that we had in Jefferson was 954 River Mist. That's where he attended, Jefferson Middle School in seventh grade.
Correct, that's what I said. So y'all moved from 2975 Rice Creek Drive to 954 River Mist Circle. And he went from West Jackson Middle School to Jefferson.
Oh,
Middle
correct,
School.
yeah, because the first was, in Houston, so, sorry.
So 6 places and 6 schools in 5 years.
That's what you had.
And you owned the 2439 Bear Creek Road in Statham residence, correct?
Correct.
But all the other residences you were just renting?
Yes.
So while you were at 954 River Mist Circle in Jefferson, a defects case was opened on your family in November of 2022. Is that correct?
I wasn't aware of that.
You don't remember them coming out to your house and interviewing you after November of 2022 into May of 2023?
Defects never interviewed me at that time.
Between November 2022 and May 2023, they never did a home visit and spoke with you at your home in Jefferson?
No.
And at that home visit, they told you on May of 2023.
Judge, we're going to object his ask and answer. It's been 3 times he's answered the question 3 times, and now we're getting into hearsay.
Let me ask you a question. In May of 2023, was there a home visit by defect where they told you there would be monthly home visits?
No, sir, not at that location.
Not at that location. What location did you have contact with defects?
I had contact with defects, in my home recent here in Bethlehem. I received a phone call at 10:30 at night from a defects caseworker that gave me instruction to get in my car and come pick up my younger children
Okay.
from Fitzgerald, Georgia, that they were in great danger.
That would have been in June of 2023? Or no? That would have been, you moved to the residence you're talking about there, it was 896 Harrison Mill Road?
Yes,
And that was also a rental?
yes,
And you signed the lease to move in there on June 23rd of 2023?
yes.
So this would have been after June 23rd of 2023?
Yes,
And you're saying that you had no contact with defects prior to that?
no, sir.
And you moved in, when did you get the call to go pick up your kids from Fitzgerald?
So, let's see, that must have been, probably I'd say it's about 8 months into that lease. I can't remember exact dates. My wife and I were separated, and it was just Colt and I living at that home and that residence at the time, and we'd been there probably, we signed a 2-year lease, we'd been there for a little over half a year, I'd say.
Okay. Would it have been that fall, 2023?
Coming up on it, yes, sir. I would say it was before Halloween.
And so you went and got the kids and brought them to that location?
Correct. I drove down to Fitzgerald that next morning with no understanding of why I was being brought down there, and they laid out why I was there. And due to the hair follicle test with my ex-wife, and the danger that they were in, and I needed to take those children.
And when you brought the kids up in October of 2023, you did not enroll them in school, did you?
I did, yes, sir. I enrolled Colin Jr. in Austin, Austin Road Elementary, and Jenny Green was enrolled in Hannah Morris.
When did you enroll?
I don't know, shortly after they got there. You know, I think it wasn't too long because I didn't want them to fall behind and whatnot, but I also wanted to give them a little bit of time to process what had happened and just, you know, let them kind of get settled within their surroundings.
But you did not enroll Cole in school until the next August, correct?
Yes, sir, that's
Okay, so
correct.
from October to August, he was not in school.
Yeah, he was homeschooled.
He was homeschooling. Were you
Online, yes.
online? Were you following that?
Yes, sir, I was.
Signing off on things?
What's that?
Were you like signing off on things?
In the beginning, I was, and he was, you know, he was into it and doing well. And then the more things kind of unfolded with my ex-wife, things kind of escalated on her side of things, and he wasn't as attentive to it as he should have been. So
How long was he doing the online programs? Was he doing it from that October all the way till the end of the school year?
he was off and on. In the beginning, he was on it, doing what he should have been doing. And as, like I said, as things happened, he kind of slacked off. And the nature of what was being done and said and escalation wise, I realized it was very hard for him to concentrate as it was for all of us.
Now, this residence is 896 Harrison Mill Road in Winker. We already established that was a rental, correct?
Yes, sir.
So do you still have the ability to go back to that residence if you make a bond?
If I would make a bond, I have a little sister, retired law enforcement, that I'm going to be able to stay with her.
And where does she live?
She lives in Cherokee County. Can you read it right? No, you're off. You come down this way. Any additional? No, you're off. This is from the state.
We do have a few. We have Terry McElhannon. He's the grandfather of one of the victims, Taylor Jones.
Judge, before we do that, I would like to invoke the legal sequestration on the state's witnesses.
Your Honor, these are just victim impact statements. They're not something that's subject to the rule of sequestration. It's not a evidentiary hearing.
Yeah, we didn't know what they were doing. So, okay. Assuming they are giving victim impact testimony, I'll deny the request. If you have any that are providing any sort of evidence, then I will grant the request.
Yes, sir. Thank you. Mr. McElhannon. Do you want him on the witness stand or stand at the podium?
Let's just go ahead and go through this.
Thank you, Your Honor. Thank you, Your Honor. Mr. McElhannon, if you could raise your right hand quickly. Swear the testimony you give right now, and you full support with the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Okay. If you could just quickly introduce yourself to the court and write your name down and spell your last name.
I'm Jerry McElhannon. Actually Taylor's dad. His dad's on the picture. Your dad and grandpa all in one.
Mr. McElhannon, we're here to discuss the issue of whether or not Mr. Colin Gray should be granted a bond. If you have something to say on that matter, please address the court.
This nightmare began on September 4th, 2024. And now, 5 months later, it's still going on. For some, it will never end. Those who lost their family, their friends, and their loved ones will never forget it. It will always has always been in their minds and hearts. I went to school on that day, September 4th, and I could not find Taylor. I asked several cops where she was. No response did I get. They set up a command center in the middle of the flagpole area, and to no avail, nobody knew where Taylor was. I was told by a student on the football field, Taylor was shot. Hours went by. Panic set in on my behalf. No one knew where she was. When she was put on the helicopter at the flagpole, she did not even know her name. And she was transferred to Grady as a Jane Doe. Still nobody knew who she was. Mr. Gray's caused this. Look at Taylor now. She has a hole in her leg, a metal rod there, and he seeks freedom today. My child, my girl, lost her freedom. We are still dealing with doctors, therapy, and a whole lot of other matters that we can't take in. You took her volleyball playing away from her. You took her childhood away from her. She's only 14 now, victim. Why should your son and you have freedom when she has none of it? She cannot do what she wants to do. She can't do anything on her own. Look at Taylor Jones today. A pitiful little kid with pride, hurt, confusion, and despair. I want to thank y'all for allowing me to speak today. We're here because of Mr. Gray's indifference, or because he just simply didn't care. I'm not here for vengeance, but to seek justice for my daughter, Taylor Jones. Because of his stupidity, he bought his son an assault rifle, not a BB gun, an assault rifle, knowing the mental challenges that they have. His son made a threat at the prior school, and when he came to Appalachia 2 days later, he carried out his threats. He had a plan of action where he made a hide and concealed his rifle, the rifle that he bought, stupid, and Cope carried out his plan of terror on the school, the victims, the faculty, and the staff. He hurt many students, and he killed 4, 2 adults and 2 children. One was my daughter's greatest friend. My daughter has injuries, and she was life-fleeted by a helicopter from Grady. She would have died too that day, except for the care that she had received, the blood transfusions, which she actually bled out on my helicopter. She received the best care at the trauma center at Grady, and after many surgeries, not just one, many, she had a steel rod placed in her leg, and we're still hoping that she will recover. As of right now, she still cannot walk. We spent 94 consecutive days in 4 different hospitals. We started at Grady Trauma. We went there to Children's Health Care of Atlanta, Showa for short. We left there, went north to Arthur Blank, and then we went back to Children. And after many visits, I can't count them all, we spent at the ER at Northeast Georgia at night when the pain was so bad that she could not stand it. There have been countless nights of sleep, no sleep, dealing with this tragedy that she has done. Mr. Gray and his son carried out an act of terrorism by buying a gun for him, and he should stay in jail as far as I'm concerned, and as far as that is concerned. He should stay there. Our lives have been changed and impacted beyond belief. Changed forever. We still deal with doctors, physical therapists, psychiatrists on a daily basis. If he's a father to his son, how could he let this happen? Our community, our schools have suffered great losses. Trust is gone. Parents are outraged. Children don't know who they can trust. They don't know who to look to. We teach our children We try to mold them to be what we think they are to be and what God intends for them to be. In conclusion, our lives have changed. There is no more volleyball for Taylor. Maybe someday in the future, God will provide a way to let her play again. But until then, I seek God's guidance. And I want to thank the police, the firefighters, the doctors, and all those that have helped. They have been all amazing to get us to this stage where we're at right now. To everyone here, keep praying that our world will change and our lives will make a difference.
No, thank you, sir. Look, I do want to, before the next witness testifies, they are going into what we believe some of the evidence is. I don't have any problem with the victim impact part, but testifying about what they believe the mental health issue was of the child, purchase of the gun, how that happened, all of that came from somebody other than us. And it's not evidence yet. We have to try this case before it becomes evidence. So I would like to be able to keep that out. I don't have a problem with the victim impact. If it deals with the evidentiary issues that we're going to deal with at trial, we would object.
The state have a response. Let me ask. I would disagree that a bond hearing, if you're saying is admissible. They're not testifying to any sort of thing they know personally. They're testifying to things that they believe and seen and heard. The court, of course, can parse through what it needs to parse through to make its decision. Just to have a civilian witness that's giving a statement on what it means to them, and the court is allowed to look at the seriousness of the charges, the seriousness of the offenses when he's making his decision, and it goes toward that. So while I understand what they're saying, I can't let them just read evidence in. There's going to be dipping and back and forth in that kind of arena, and I think that the court's instructions should be limited to what that.
Anything else, Mr. Barry? We don't want to take the witnesses that may come out, the jurors that may come behind. At this point, I did hear a number of things that were apparently information that they had gathered from some source, either news media or attorney's office or somebody. Because we haven't heard evidence in this case at all. So that's what I'm concerned about. I just don't want the evidence to come out in this type of setting. It's just not the proper place to do that. Yeah, certainly I understand that each of these people have a right to give an impact statement. I also am certainly aware that I'm not taking what they say as evidence about the facts of the case, about what happened in the case. That will come later through a trial or other proceedings. That's not what the bond hearing is about. I don't know that I can expect them to divorce their impressions of the case from their emotions and what it is they want to tell me. That's a difficult thing. I will point out, we obviously have news media coverage here. One of the concerns at some point down the road is trying the case and being able to find a fair and impartial jury. So anytime a witness is going into facts, whether they're accurate or not, that is going to make it harder in the future for us to pick up a fair and impartial jury, which is necessary in order to try the case, of course. So In essence, I'm going to overrule the objection because I don't think I can expect the witnesses to divorce their feelings from what they've heard about the case. I'm not taking what they say as establishing facts about what did or didn't happen. Okay. All right, we call your next witness.
Can I say to call Rick Aspinwall? For the testimony of you.
Aspinwall.
Mr. Aspinwall, we're here to talk about issues of bond for this case. If you could, to the best of your ability, to keep away from the facts that you may have heard and you know about the case, and just talk about how the impact was on you and your family in this case.
I can tell you that it's been devastating for my family. I have 2 little girls that's going to be growing up without a daddy, 2 granddaughters. My daughter is devastated. She's lost a job. She's trying to recoup, find a new job. But it really affected her emotionally as she served 2 tours in the Army. And it struck her real bad. By trade, Mr. Gray, I am a heavy civil general superintendent. I've had hundreds of men work under my direction. I've seen men like you many a time.
Mr. Aspinwall,
I'm not gonna say anything else.
I'm just going to have to ask you to address your testimony to the judge. That's who we're talking to today.
I will say that due to some actions instigated or by accident or whatever, that it has affected everybody, the entire state. I've been working with the state to try to make changes. And hopefully it'll come about. But what happened is inexcusable. Inexcusable. I don't know what else to tell you. If I say any more, I'm liable to get in trouble.
Thank you, Mr. Aspinwall.
No question. No question. Thank you, sir.
Brianna Shermhorn. Could you introduce yourself to the court reporter and spell your last name for her?
My name is Brianna Shermhorn, SCHERMERHOR.
And what we're here to talk about today is bond for Mr. Gray. If you could address the judge and let them know your feelings about bond without going into any of the facts of the case that you may or may not personally.
So I will say that I struggled personally with the cost of letting I was trying to Mr. Gray out on bond. It turns into obviously a matter of letting the judicial system do its job, working to maintain and protect custody when he's released to the public, where you have a equivalent more of a chance of street justice taking place. Since my son was murdered on September 4th, 2024, I'm still torn on which should be allowed to happen. I feel like the sheer irresponsibility of Mr. Gray's appearance brought my feeling of which he has raised my son. Mason had a great inherited future ahead of him. He was an amazing son, brother, and friend, and he loved unconditionally. He possessed an innocence that you could not imagine. For the turmoil that Mr. Gray felt in her in September 4th. And then I hope that move on to his grandchildren. And honestly, I'm very under the prison. And then not to allow him to have any impact or influence on any
school year. That's, thank you, ma'am. No question. Let me know.
Yes, sir. Yeah, good. You swear the testimony given that matter not being before the court, the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Could you introduce yourself?
I was Richard's father-in-law.
Mr. Zink, take your time. We're here to discuss bail today. If you would address the judge about the impact this has had on your family.
It's been a tremendous impact in a negative way. We've all been devastated by this. I lost not only a son-in-law, but a close friend. I miss Ricky every day. Every single day. We are blessed with his children, and my wife and I get to spend more time than we should with them. Absolutely more time than we should ever have to spend with them. I love them, but it's just a daily reminder that Ricky is gone. Ricky is no longer with us. And he was a positive impact on those children. Absolutely a dedicated father, involved in every aspect of their lives. And it is just so hard to look at them and be joyful for them. And they are beautiful. My condolences actually go out to all of the victims of this tragedy. T.A. Smith said to me in the very beginning, you do not have to be struck by the bullet to be a victim of this. And I couldn't agree more. There have been so many victims and so many people have come forward. And I really had a statement prepared, but I'm not going to read it. I would like to thank the first responders and the sheriff's department that reacted so quickly. I know they saved lives, and they have been so involved with us since. And the sheriff himself and Lieutenant Wilkerson and all of them have just been so helpful in getting us through this. And as far as the bail goes, I know there's criteria that have to be met. And I'm not going to stand here and judge anyone. It's not my position here. But I do know from, the facts that have come out during the original hearing that Mr. Gray's actions are responsible for what is taking place. I mean, him buying, I did write down one part that I don't even have to read it, that the statement about a shooter's outfit. When you buy a complete shooter's outfit for a 14-year-old boy, what is supposed to be the outcome of that? The consequences were grave. The decisions he made were unimaginable. I don't know how anybody could do what he did and buy those things for a 14-year-old boy and then not have any supervision, no involvement, no positive parental involvement. And I have 5 wonderful children and have been so involved in their lives and would not trade. I don't know how you can just, I don't know how you can just live with yourself sometimes. I don't know. Because this is horrific. You have devastated the lives of, like Richard said, the whole state, the whole country. This is a devastating act, and I just don't understand. It just makes me so angry when I heard my wife is devastated. She is a ray of sunshine. You've taken her best friend. We did more family activities together than you can imagine. Every chance we did. And Ricky was just a huge part of that. I mean, he was just the most giving person I've ever known. And just a positive influence. I don't think anybody would disagree. He was an excellent mentor. He loved his students. He loved all of his team. He loved everything. He loved life. And you have taken the life of just a
fantastic person, and it's just, I haven't slept well since. I really haven't. This has just been extremely devastating. So, like I said, it's not my place to judge, but I would, at this point, seeing the actions and what has come of them, and one of the criteria is threat to society, then I can clearly see where bail should not be allowed for that reason alone. Thank you.
Thank you, Mr. Lee.
Thank you.
We have a brief audio recording from the wife of Richard Aspinwall, Shana Aspinwall.
It's simply audio.
Yes, sir.
Yeah, I think it is set up to play right now. If you want to try.
My name is Shana Aspinwall. I am the wife of Ricky Aspinwall. Thank you for allowing me the opportunity to express my feelings about Colin Gray and his potential bond release. For the benefit of the court and for the protection of the process, I want to keep my statement short at this time. However, here is what I know and what I feel. Colin Gray knowingly allowed his minor son to have access to an assault weapon. There is absolutely no justifiable reason for any parent to let their minor child, particularly one who has shown some signs of concerning behavior, to have access to an assault weapon. The outcome of Colin Gray's decision was predictable. Along with the families of the other victims, my 5-year-old, my 2-year-old, and I are now forced to live with the consequences of Colin Gray's choice. Colin Gray has clearly demonstrated for all the world to see the type of judgment he possesses. Someone with this type of judgment should not be allowed into the outside world. My children and I, along with the other victims of the Gray family's actions, deserve better. We humbly ask that you deny any release. Thank you.
Lastly, Your Honor, we have a written statement from David Phoenix, PhD.
September 4th was filled with hurt healing process due to the events of September 4th. September 4th was filled with hurt, hatred, and darkness caused by a 14-year-old student whose actions were driven by the decisions, choices, and actions of his father, Colin Gray. As a result of these choices and actions, the amount of pain that was inflicted on the school and the surrounding communities was unmeasurable. Lives were lost, people were hurt both physically and mentally, spouses were widowed, parents lost their children, and children lost their parents. There's a great degree of everlasting pain and hurt that will never go away and always be felt by students, parents, and members of the community. For me personally, I was shot twice, once in the hip and once in the foot. I spent 8+ days in the intensive care unit at Piedmont Athens Hospital. I've had 2 surgeries that involved rebuilding my hip, as well as multiple follow-up appointments to the orthopedic surgeons, physical therapists, personal counselors, as well as other medical doctors. While my diagnosis is good and there will be lasting effects from these injuries that will impact and affect me throughout the rest of my life. Our school and community are slowly healing from an immeasurable amount of pain. We have come a long way from 5+ months ago. Releasing Mr. Gray on bond would essentially rip off the bandage of that healing and create the very anxiety, hurt, and pain that we are trying to heal from. Mr. Gray does not deserve bond based on the inexplainable decisions and choices that prompted the deadly actions of his son on September 4th. Conversely, our school and surrounding community deserve peace of mind and comfort knowing Colin Gray is behind bars. It is for these reasons that I'm asking you to deny the bond of Colin Gray. David Phoenix.
That's all we have to say.
Argument. it's okay if I just stand here? Yes, sir. Of course, the event took place September 4th of last year. Certainly devastated the community. Many of the people who testified lost people and injured. Mr. Gray, let me get you to at least pull that microphone towards you. Scoot around. You can, or you can go to the podium person. Sorry to interrupt. No problem, Judge. And we certainly see from the witnesses that testified and all of the things that we've seen in the newspaper, it's evoked a lot of emotion with everybody in this community. This is an unusual case. There have not been any cases of this type tried, only one that I know of in the United States where a parent has been charged with crimes of their child. I would like to point out, of course, as the judge knows, Mr. Gray is innocent until he goes to trial. He's found guilty by a jury of his peers with competent evidence. That's not taken place yet. The purpose of the pretrial bond is not to punish him before his conviction. And that's why we have set out certain standards. The ABA back in 1968 set up standards. The courts here in the state adopted those standards. Cases that came shortly thereafter, Lane versus the state at 247, Georgia 387, Burge versus the state at 238, 88, Ayala versus the state at 262, 704. All of these cases set out a criteria. The criteria is 4 different areas. 1, that a person poses no significant risk of fleeing from the jurisdiction of the court or failing to appear in court when required. The state has the burden of proving each of these 4 areas would be in violation. They have not done that. There's been no evidence that's been presented as to the first area, which is the fleeing the jurisdiction. He has been in Georgia all of his life. He's lived in and around this area. The state pointed out that he had moved a number of times. However, all of the moves are within a fairly short area. The second, poses no significant threat or danger to any person, to the community, or any property of the community. The state has not shown that he would pose any significant danger. He had a misdemeanor marijuana charge 26 years ago. That's the only thing that the state has been able to show the court from that standpoint. Number 3, poses no significant risk of committing any felonies while out on bond. The state has not shown that he would be subject to committing any felonies. He's, I think, 54 years old. This is the first time that he's been in any trouble other than the 1999 marijuana. Poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. The state has not brought any witnesses before this court to show that he would be any significant risk of intimidating any witnesses. He's been in custody for all this time, has not caused any problems while there in custody, has not attempted to contact any witnesses or intimidate any witnesses while he's been there, nor is any of his family. For those reasons, Judge, he certainly is eligible for bond. We feel that the court should grant him a reasonable bond under the Iowa guidelines, and ask the court to give him a reasonable bond for that reason. Thank you.
Anybody wants to hear him?
Your Honor, under 1761, a court shall be authorized to release a person on bail. Not that you have to, but you're authorized to release a person on bail if the court finds all of these factors. First one being that the defendant poses no significant risk of fleeing. Your Honor, I think the evidence today has shown that he has no ties to this community. Closest he could come to were some sisters and daughters that live in the metro area, is the best we've heard. He has a history before the crime. He had an incredible history of moving. He had 7 different residences in 5 years. Hall County, Forsyth County, Ben Hill County, which is almost in Florida, Jackson County. He's moved to all of these places. 6 of these residences were rental residences. He also showed a significant risk of fleeing, Your Honor, in his candor to the court. Your bond would be an order of the court to come back to court. And even in his own testimony, he was asked, have you ever been arrested? And he said, no. Not even a misdemeanor? No. And then we pointed out twice he had, which is not going towards his risk to reoffend, Your Honor, but it goes towards his lack of candor to the court. And it also goes to his no ties to the community. That was in Cobb County, Paulding County. He's all over the state, Your Honor. The next factor, no significant threat to the community. Your Honor, this was an attack on the community. This wasn't a domestic violence where you're attacking a specific person or a robbery where you're going after a specific thing. This was an attack on the community, which makes him a serious risk. There were 25 total charged victims in this case. The next factor, no significant risk of intimidating witnesses. Your Honor, the state is going to need to prove what happened in his household leading up to this shooting. And the witnesses are going to be his wife, his 3 children. Those are our main witnesses in this case. And they're his. And so there's a significant risk of him intimidating or influencing these witnesses. Your Honor, we would ask that you not grant a bail in this case for those reasons. The court, if you do decide to set a bail under Jones versus Grimes, 219 Georgia 585 case, you can consider when setting a bail and the amount, the seriousness of the offense, and the penalty of those offenses. So if the court were to grant a bond, again, we're asking that you not, but if you were, he's charged with murder in the 2nd degree, 2 counts. We would ask for the bond to be $100,000 per count, a total of $200,000. He's charged with involuntary manslaughter, 2 counts. We would ask that the bond be set at $75,000 per count for a total of $150,000. He's charged with cruelty to children in the 2nd degree, 20 counts. We would ask the bond be set in the amount of $50,000 per count for a total bond of $1 million. He's charged with reckless conduct, 5 counts. We would ask that the bond be set at $1,000 for a total of $5,000. So if the court were to grant bond, we would ask for an amount of $1,355,000 bond, which would be appropriate for the seriousness of these offenses. We would ask that you have no contact whatsoever with any of the witnesses in this case.
Any last words, Mr. Gray? No, Your Honor. I think we've set out the criteria for setting a bond. We don't believe the state has proven any of the 4 elements that actually keep them from getting a bond. I'm going to take about, I'll call it a 10-minute recess. Hopefully that's sufficient time, but we'll be in recess for 10 minutes or until. We're all present. Mr. Gray is back in the courtroom. The community has great interest in the case, which is certainly understandable. So I'm going to give a detailed explanation here. What you, the families, are going through, what the community is going through is it's undeniable pain, and I understand that. The emotions that the community feels are overwhelming, I'm sure. I don't know that you can, but understand that the law does not permit me to be emotional, and I'm constrained by the law. Now, a statement was made, again, understandable, that I'm here to seek justice. Understand that at a bond hearing is not where justice is dispensed. Ultimate justice, in whatever form that takes, comes later through a jury trial. The law at a bond hearing is that the accused is presumed innocent. Now, that's despite whatever's been said about the case through the media or through a first appearance hearing or through any other avenue. As we sit here, the law presumes that Mr. Gray is innocent. No facts have been established in this case yet. Again, despite anything that's been said before. Those facts will come through other hearings, they'll come through a jury trial. Now, the legislature in the Supreme Court, and it's been referenced, have laid out factors that constrain courts in determining bond. One is a risk to flee. Now, what that normally looks like is someone has prior failing to appear at court convictions, or someone has in fact fled charges before. That is not what we have here. Another factor is danger to the community. Now, if we assume guilt, that danger is obvious. But I'm not allowed to do that. He's presumed innocent as we sit here. There's no independent evidence that he's a danger to the community. There's no recordings of him in jail saying he's going to do this when he gets out. There's no prior crimes where he has done something else that puts those in the community in harm's way, which leads into the next factor, the risk of committing a felony while on trial. I think it was said that he's 54 years old, 50 some odd years old, has no prior felony convictions, has a 1998 or 99 marijuana misdemeanor charge. The fourth factor is intimidating witnesses. Generally, again, there's evidence of that. He's making jail phone calls, trying to get someone to change their story. He's making statements about what he's going to do so that this witness can't testify. We do not have that in this case. Now, the legislature nor the Supreme Court have said that one of the factors for determining bond is the impact on the victims. It's not one of the factors that I'm supposed to consider in granting bond. Now, having said that, the foremost consideration in determining bond is whether or not the accused will appear to stand for trial. And I do have grave concerns here. This is not the typical case. In an ordinary case, the defendant's given a bond, he makes the bond, he returns to the community, essentially unnoticed by anyone. That's not what would happen here. This case is an open sore. It's a wound that continues to hurt the community. While in court, Mr. Gray is presumed innocent, in the court of public opinion, he bears a scarlet letter. I don't believe that there's any way that Mr. Gray could return to this community as an accused often does when granted a bond. Now, his ties to this community are minimal. The state has pointed out that he has moved and lived in 6 or 7 different places over a relatively short period of time. I am allowed to consider the charges and the punishment that he faces if convicted. And were he to be convicted of at least 29 charges, he faces the prospect of the rest of his life being in prison. And that is something I'm allowed to consider. So weighing all of these considerations, I believe that it is, one, required to give a bond, but 2, given the extraordinary nature of the case and the other factors, that it needs to be a high bond. I'm going to grant a $500,000 bond, which is necessary to ensure that Mr. Gray appears at trial. I'm going to require 10% of that to be a cash bond. As a condition, the bond is to have no contact with any of the witnesses whatsoever. I'll prepare more.
Thank you.
All right, Jeff, we need to take up anything else. I know that we had a conference call. The case is not going to be, it's continued off of this trial calendar that I'm in court for today. I think the defense indicated you'd be filing motions in the next week or so. Is that right?
That's accurate, Judge. Yes, sir.
After those motions are received, reviewed by the state, and we'll discuss the scheduling order.
Thank you. All right, be excused.
Thank you,
Yes,
Judge.
thank you.
Oh, fucker's muted. I'll just go back to the other trial for a second. They're still on verdict watch, 1 hour now. I agree. I think everybody should have the right to have. Well, I don't know if I agree with that. They say that every defendant deserves a right to bond, or at least to be able to. So I agree with that, actually, to a certain extent. But what if you? I don't know. I think 99% of the time, everybody should be granted bond, but in a lot of cases, it doesn't matter. I think the magnitude of it, like, it could be a $10 million bond. I don't care. As long as you get, everyone has a right because you're innocent unless proven guilty. But then there are some cases I'm like, but there's videos of them killing somebody. So I don't agree that they should have that bond then. But then am I being hypocritical on that? I'm thinking about the one Chad, you know, that Chad guy who killed his 3 sons. You know, the gun was in his hands. He obviously 3 children. I don't agree that he should get bond. You know, but then am I being hypocritical? But yeah, I don't know. But I do think people should be. The majority of people should be allowed bond or whatever. Yeah. Yo-yo almost. Are you gonna yo-yo, lazy? Yo-yo. Right, Deb agrees. So I'm trying to explain that in the right way, but I think you will get what I mean with it. So just for my clarity, cash bond then, you guys, wicked smart. I'm wicked smart, everyone. Dana! Dana's here. Yes, let's go, Dana. Absolutely not. He had to, yeah, but I was using him as an example, Heather. Do you know what I mean? Those kind of cases where you know, but then that's a fine line because we don't officially know. You know, he has to be tried. You know what I mean? So it is a little bit of a grey area, I suppose. Wicked smart. Oh, I forgot what I'm going to fucking say now. I blame Dana. I blame Dana for this. Oh no! I just ripped my socks. Fuck! I put a hole in my sock. Again, I blame Dana for this. I blame Dana for this. I don't. I love Dana. I forgot what I was going to say. I have no idea what I was going to say now. Oh yeah, no, cash bond. Yes. So explain this to me because I actually generally don't know this, right? Cash bond, because you've got a bond. Do you always have to give money for a bond? 10%. Like he said, cash bond. So what does he physically have to get the 50,000 in cash, or because some bonds aren't cash bonds, they're just 10%, but you don't have to give that. You just have to put equity towards it. Is that the case? I presume that's the case. That when he says cash bond, you need to present 50,000 in cash. Cool, but in some cases they say $100,000, but they don't say cash bond. Does that mean then that you signed it? Like Dana would sign for me and says, I will pay the 100,000, but I don't have to put anything towards it. So let's say your house is worth 1 million. You have to put 500,000 up for bond or 10% cash bond. Okay, I'm with you. Okay, I got you. So yeah, so you wouldn't have to give the 10% then. You would lose your house. I'll walk through Dana. What is Dana writing? Because I haven't seen his chat. Let me go to live chat. Let me go to live chat. So yeah, what Vix is all about. So basically, your house is considered cash bond. No, your house is considered equity for. So for instance, if he instead had cash bond, it would be 500,000 on his house or on someone's house, but not 10%. But because he said 10% cash bond, they have to physically give 50,000 as well, which is obviously a lot of money. Like a lien on your house with 500,000. Yeah, so it's like if he does do a runner, you lose that 500,000. So what Vic's is saying, 2.5 miles. So me and Dana, I haven't told him this yet, Dana. I'm going to do a slightly different Dana, right? So because from my house to the Sweeney's house is 3,098 miles, right? So round it up. He has to do both, yeah. He has to find equity for 500,000, yeah. But he's got to find the 50,000 and then the equity as well. But a bondsman would probably give him the 50,000, maybe, would they? So riding up to 3,100, right? So 3,100 miles. Dana wants to do double it to make it 6,200. So that's 6,200 is how many steps we have to do per day. So that, we have to do 6,200 per day. So it's equivalent of walking to Boston and back, as in, you know, same mileage, but in steps. What Dana doesn't know, I'm going to do slightly different. I'm not putting this on Dana because he's a busy man, he's a working man. On Tuesdays, I have gyms and stuff like that, so it's going to be hard for me. I'll do the 6,200, but I at least want to, on 5 different days, do double that to 12,400. So they're back. So Dana, in fairness, he's a working man. He's a working, yeah, per day, Vix, per day. So he's a working man. So he can't do that. So the 6,000 will be good for him. But I'm going to aim for at least 5 days of them to be 12,400. The other 2 days have to be 6,400. Because I need to push myself a little bit. Tuesdays are difficult for me because I have got the gym and stuff. I'm out the house for like 2-3 hours. So it's quite hard for me to fit it in plus stream and do everything, you know what I mean? And also Sundays, Sundays are hard because obviously I see family, I do stuff. So that's also quite hard for me to do the 12,500. But every other day I should be able to do it throughout the day. I'm confident I'll be able to do it because I used to do 5 miles anyway. So yeah, the minimum is 6,200 steps per day, but I'm going for a little bit more. So basically, I'm going to be doing an equivalent of 74,400 steps per week. Dana's in. So what we'll do, Dana, is this, right? Let's go for 74,400 a week. What that means is, if you can do it every day, happy days. For 6 days. Is this making sense? So if you do 12,400 every day for 6 days, that's 74,400. Right? It gives you 1 day off. Do you know what I mean? So I say that because I know there's at least probably 2 days I'm going to struggle to do that because of family commitments and stuff like that. So I'm still going to walk 7 days a week, probably. But do 12,400 5 days a week and do 6,400 at least twice a week. Now, if I manage to do the 12,400, happy days every day. But I'm going to give myself grace days. So the total every week needs to be 74,400. That's the equivalent of 6 days a week of 12,400 steps. Does that make sense? So you might do it all in 7 days, but that's the equivalent you need to go for. Does that make sense to you, Dana? And is that fair, do you think? Because it gives you that grace, do you know what I mean? As well, because things do pop up and, you've got to travel, there's things that we have to do and stuff. So I'm just thinking it gives us that 1 day grace if we do need, like, I know I need to go to the hospital one day, and I'll be probably out of action all day, and, family stuff, and this, and, there's always something. So I think giving ourselves that one grace of, like, in case something comes up. Now, if nothing comes up and you're able to do 12,000 per day, happy days. But I think we give ourselves that figure of 74,400 per week. See, Deb, we're going to be here for hours. We're going to be here until the verdict comes in. So we're here for hours, my darling. So you might be back later on. We'll still be online. Pop in. Dana's in. Fine. So Dana, starting Monday, 74,400. I just think that's ambitious, but also doable. Do you know what I mean? It's ambitious, but doable. So Vix is in. Is Stacey in? I'm in the basement too, guys. Work from home office and real life in office are both in the basement. There you go. Well, get your ass out of the basement. Let's go. Just do whatever. Do as much as you can. Raining here. Yeah, if it's raining, I'm going to do it inside on the treadmill. Do you know what I mean? So this is just, hey, people can join if they want to join. You know, we'll keep receipts. Me and Dana will have to message each other every day, probably the next day, with steps that we've done. We'll keep it on the Apple. We'll go by what this says. We'll go by this. So every week, you know, where the Apple data goes. I never use my phone anymore, so I need to take my phone everywhere now. You know where it says, where is it? That thingy, majiggy. That thingy majiggy. That thing per week, we're able to see that then. And starting Monday, so technically for me, that'd be 1, 4, 3, 4 times whatever for the week. Count it all up. So there we go. Stacey's in. Like again, set realistic goals for yourselves. Set what goals you think. Dana Leonard's going to get tired of you. Going to? Question mark. There you go. Betty going, oh yeah, no, I'm not going to. I can't do that, Heather. I appreciate you though, my darling. You're a weirdo. I appreciate you. Yeah, I think anyone who wants to join in, it's just a little. It's something that it motivates me, so I think it'd be good to do it. There you go, Stacey. Join us. 12,400. So 70. Oh, what the fuck was the figure again? 74,400 per week, Monday to Sunday. Start Monday. Yeah, because there's no point starting it, you know, tomorrow, Thursday. Start Monday. The challenge is what Dina says, having your phone on you, because that's my main challenge, is keeping the phone on me. You know, especially because I walk around naked all the time. So it's, where am I going to put it? You know, I'm going to have to put it in a hole somewhere. Up the butt. No, I won't do that. No, I do wear PJs sometimes. So yeah, that's part of the process, is how do we do it. But yeah, I'm looking forward to it. I need a motivation, and it's keep each other accountable. I got a smartwatch, but I don't wear it because I get rushes. I get rushes on my there. My skin's so sensitive. Got a couple of mates who sponsor me. There you go, sponsor. We should have done it as a sponsorship, shouldn't we? All money goes to Karen or something. I didn't think about that, but I mean, probably no one's going to sponsor anyway. But I'm so sensitive. Yes. Don't go breaking my heart, Mecky. Mecky broke my heart loads of times. You just need a new strap on. I mean strap. No, it's not the strap. It's the metal casing. It's a metal casing. It always gives me a rash. The thing itself is fine. It's the behind it, the metal thing behind it, that gets me every time. It's not the straps. It's just that thing. It's annoyed me. I have the energy, but not the desire. So my problem, I know. My problem is I don't have the energy, but I have the desire. They make covers for the faces, but I don't think it then works as well. If I remember correctly, it's the underneath bit. I don't think it works as well. Is it nickel? Yes. Yeah, it's metal, whatever it is. Anyway, it might be nickel. Yeah, I get very sensitive to it. It's not just every watch. Every watch I get rash on it. I try. It's just my skin. Honestly, I come out in rashes all the time. So I've had some very rare rashes that people don't know about, as in doctors are like, what's that? But I don't know. You fucking tell me. That's me. I'm here to see you. I know what it is. So yeah. And the worst thing for me is I got a rash all over my body, right? And this disappeared now. They think it's stress related, potentially. And then they were like, yeah, we'll do a biopsy on it, but it's gone now. So I'm still on the waiting list though for biopsy. I think the problem is, mate, the only reason I'm shooting it down is because I think you need it to touch your skin for it to work on smartwatch. That'll probably work on normal watches. You're right. If you talk on a normal watch, Becky, you're 100% right. You're probably right. But on a smartwatch, you need it to touch your skin. So, but on a normal watch, you would be, I imagine you're probably right. So I'm not shooting that down. Just, I was talking more smartwatches, not normal watches. Oh, shit. I have something between my legs. Oh, down, boy. Down, boy. Who's this? I'm excited now. We should have a punishment, though. If you don't do it 1 week, there should be a punishment, though. And not bad punishment, but there should be something. Because, I don't know. They do covers, but I don't. I'm trying to explain it. Maybe I'm not explaining well. The part that there's a part I can't have covered. The part so you're right. There's covers for them, but it covers. It covers a part it shouldn't cover, if that makes sense. The part I need to touch my skin, it covers that. And I need that to touch my skin. Yes, this is from Kathleen. I got it this morning. She posted it from fucking bitch, Mecky. I love you, but you're a bitch sometimes. I got wicked smart. I got Kathleen Diakos sent me this. She wore it, and I was like, oh, those are great, and she sent me one. I like it. I like it. It's so smooth. I like it. Oh, you're such a bitch, Mecky, to me. Mexi, she's so nasty to me. It's unbelievable. But I can't help but love her. So, oh, I'm not done it today yet. Mexi, I was waiting for you. I need to put some white stuff on my face. So yeah, what we're gonna do if we don't reach the goal, Dana? I mean, I think we should be accountable for something. I don't know what. Hey, Brenda. How you doing, my darling? Yeah, this is the mango one. Vanilla and mango. I prefer it over the Lush one. I much prefer this one. This is my favourite now. I've tried the pineapple one, but this is the one I like. I'm okay, thank you, Brenda. And you're also right, Brenda. I do love it. I don't know, Dana. We've got to think about a punishment. Not punishment, but if we don't do something 1 week, we both get punished if we don't do it. Not like you get. I don't know. I don't know. We need to do something. 1 hour, 20 minutes for the deliberations. How's that now? I know I need to shave. I know I need to shave. It's a bit of a mess, but I forgot to do it earlier. I need to shave, and do you know what? I might do it this weekend. I might shave and cut my hair, because I might shave my hair off. Both have to put pedos on for real. Speedos, I meant to say, for real. Fuck. I mean, if I had a body like that, I would. I'd be a beach fucking whale, Lady Di. If I put speedos on, I'd be beach whale. They'd be like, what the fuck's that? We need to get Dennis Sweeney involved as well. Fuck, hang on. Let me phone Dennis Sweeney. Where's Dennis now? Is he online? Let me see. Dennis will join us. Let's see. Hang on. Hang on. No, he's not online. Oh, he's out somewhere. Well, oh, is that the thing? Oh, Lisa Reed. Hang on, Lisa Reed sent me a photo. Lisa's on the cruise. She's having a great time. You can see from her she's having a great time. Awesome. There you go. Hello, Lisa Reed. Right, I'm going to text myself. Right, let me show. I know you sent it to me to show, so let me show this first. This is Lisa Reed, everybody, and hubby. Hang on, let me get this for you, Lisa. I was going to say, let me get this up for you, Lisa. Oi, oi! I'm sure I don't need that. Right, let me get this for you. This is Lisa Reed and Mr. Reed. Oh, let me get it here. Here she is on the cruise ship, enjoying herself. Not fair. Lions gear on. Happy days. The Lions are here, and then hang on. Where's the other one gone? Oh, I need to go into the other one. There they go as well. Mr. and Mrs. Reed. Hey, looks like you're having a great time. Lions tops on. That looks like a fucking great ship, mind. Bit lopsided, but look at that. Happy days. I love the fact you wear Lions gear as well. I love that. You both do. I love it. Right. You see, you got your Lions gear on, we got our Speedos on. Let me do this, let me do that. We got that. We got that. It is so fun, isn't it? I love it. It's so fun. It is. It's great. I love that. Right. Got that done. Right. So I don't think there's any punishments, Dana. I think we're okay. Dennis is not here. I was going to say to Dennis, you can join us. If Dennis comes back online, we'll ask him if he wants to join as well. Hey, Mary. Mary, how are you? Mary Moiro, RNU. Mr. Reed's currently playing cornhole. There you go. Mr. Reed's out there hustling out there. Lovely to see you, Lisa. It is always nice to see you when you're popping into chat and stuff like that. We miss you, but it's good. It's good. We're on Verdict Watch, by the way, so although Australia, I'm taking you all with me. Yeah, let's go with you, Lazy Die. Let's go with you. So that's the thing now, because I've got a stand-up desk. I can just walk on the spot as well if I need to get some steps in. I'm excited for Monday. I'm not really, but I'm excited. I have to say I'm excited. And then fuck. Thank you, Dana, by the way, for agreeing to do this. This is good. This is what I needed. This is the push I needed. 74,400 steps per week. I might try and do it every Friday. By every Friday, done. I won't be able to do that. No fucking chance. But some days miscellaneous stuff, isn't it? You know, you might get like 15, 16,000 in one day, maybe. So, you know, I just think it's better to do it that way, because especially if you know you've got something on the next couple of days, like for Dana, you know, you've always got family, you might have to do something, you know, or you might have to drive somewhere for like 4 hours and it's hard to get the steps in. Well, if you know that, you can pre-plan it and go, right, okay, so today I'm going to do X, Y, and Z. Lisa Reed's in. Lisa Reed, I think you're fit enough anyway, so you're all right. You could probably double what me and Dana are doing. You could probably do 24,000, 28,000 steps. Lazy Die says, yes, not excited, but once you begin, you feel so much better. Sometimes. I used to love doing circuit training, but I've got no energy for it. So I dread it every week now because I've got zero energy. And I don't work out as well as I used to. But, you know, we could do something. We're going to be the sexiest chat room around. Tops off for the lads. Yeah, I'm definitely going to be weighing myself as well. I need to weigh myself every Monday as well to see that, if I can progress on that as well. No, it's good. Because I know in Boston I'm going to be eating like a fucking anything. Do you know what I mean? So Lisa loves walking and talking and snorkeling. I'll join and do it on my tread climber perfect because I haven't used that thing barely at all since buying it. There you go. You know, we got to hold ourselves accountable. Do you know what I mean? So do it. Everyone. And you don't have to do the same as what we're doing. Do whatever, you know, you feel comfortable and you push yourself a little bit. You know? But yeah, I love, you know, I love this shit. You know, it motivates you. Do you know what I mean? So we can have a check-in every Monday or something then. Right, where are we at? How much did you walk last week? Or whatever. Well, I don't know. We'll do something. Because how long have I got until I have got... Let's have a look here. Let's have a gander here then. Hang on. Let's have a look on the Drunken Sailor. Or let's have a look on the Drunken Sailor. Let's have a look on the Drunken Sailor. Dana is his name. Oh, Dana. He's a drunken Dana. He's a drunken Dana. He's a drunken sailor. Calendar. Calendar planner. Right. Google Calendar. Got it. Have you got it? Yeah, I got it. Hang on. What the fuck is this calendar? I have no idea what this calendar is. Jeepers, I must have done something here because I have no idea what I've done here. Right, let's go back here. Sea Dog's around. Sea Dog only wants to cover Karen Reed stuff. Sea Dog isn't a fan of anything else. Right, let's get this up. That's what she said. Right, let's get this up, people. Google Calendar. So, if we start on Monday, the 16th, so that means I've got 1, 2, 3 going into May, sorry, 4, 5, 6, 7 to the 5th, 8, 9. I got 9 weeks. 20th is my birthday. 21st, Dublin, come back from Dublin. Dublin, come back from Dublin. So that's 9 weeks. This is going to be tough for me. This is going to be tough for me because I'm going to be in Dublin. My birthday on the 20th. Traveling to Dublin then Monday, Tuesday, Wednesday. She said Shanti. Ah, nice. So that's the 10th week. Then I got 11, 12, 13. Hang on, let me put this as a week then. So somehow I must have done this. So how much did I say? 10, 11, 12, 30, 12 and a half weeks until I go to Boston. Fuck. I don't remember doing this, but apparently I put in the landlord in the corner, going to Boston, and then coming back on the 28th. So 12 and a half weeks before Boston. But I got 9 weeks until Dublin. Yeah, you can do, Stacey. You can do something. I don't know how we work. Or maybe, yeah, we could do, yeah. You can send photos and stuff if you want. Yeah, we could do that. We could do that, especially Stacey. Let's do that. Yeah, let's do that. So, yeah, there you go. I've got 12 and a half weeks until then. Fuck. That's, you know. You can post your either daily goals, weekly goals, whatever you want then. Let's put it in here. Walk-in challenge. Create channel. Right, I've done it. New channel for those who want. Walk as my you want. Send now. So there you go. It's there. Stacey, should we just see it, my darling? There you go. And obviously I will say announce this. Oh yeah, because I can then, if you do it every week, then on Monday or something, I could just say, all right, Stacey, lazy bitch, she's not done enough this week. I could be like, hey, Stacey, get off your fucking ass, Stacey. Get off your ass, Stacey. Come on, let's go, Stacey. You know, we can go do a bit of that. So Dana, right, let's get back to the start here, Dana. This is what I was doing here. Hang on. So we started Monday, Dana, and we. So that's 1, 2, 3 weeks there. 4, 5, 6, 7, 8, 9. So it's 9 weeks, right, up until the 19th. The 20th is my birthday. 21st, 22nd, 23rd, Dublin. So travel to Dublin on 21st, Dublin, and then Dublin and travel back on 23rd. 24th, 25th, 26th. So that's 10 weeks, 11, 12, and then it's like 12 and a half to Boston. So 9 weeks until Dublin, 12 and a half weeks until Boston. And you see also corner there, Boston. To the 28th. We got spring bank holiday then as well. Ooh. So this is a challenge for me that I'm doing up into Boston, people. Okay? After that then, you know, whatever, but definitely doing it up into Boston. In Boston, I'm not doing it in Boston because I'd be fucking, hey, what time UK? I didn't hear about Dublin. Yeah, I'm going to Dublin. So my birthday, Katie, is on the 20th. As you can see, it's Easter Sunday. So this week, the 13th to the year, Good Friday, 13th until the school here in the UK stops on the 11th of April, and they're back in school on the 27th of April. So for my birthday, I used to live in Dublin. My father loves Dublin, my mother loves Dublin. Obviously my family enjoy it, so we're just going to go over for a couple of days to go over there, catch the ferry over, reminisce a little bit, and come back. So we're just doing it because it's, my birthday, plus it's, why not? We've been to do it for ages, doing it in Crocs. Stacey loves it, I love it. It's changed a lot. It's so expensive now. That's why we're doing it for 2 nights. We're not doing it, Monday, Tuesday night. We're not doing it like along because it's just so expensive. Even flights are expensive. So we're gonna do a ferry journey. So there is outside Temple Bar. You're right. There is. I don't think I've been Temple Bar is not really my jam. When you lived in Dublin, Temple Bar is not somewhere you go to because it's like it's too expensive. So I'll be in North Dublin more than likely. So I used to live in Dundrum, Sword, Leopardstown, all these places. So I want to go and visit some of them again and reminisce. So so catch a ferry, go up there, and then come back on the Wednesday, 23rd, and then so that's the current retrial. So I'm hoping I got some plans for people to help me out. So there'll still be a stream here, and I'll try and pop in on my chat and stuff, but I won't be here to actually do it, if that makes sense. But I'll be back on the 24th, then I can do it then, for wherever the trial lasts, and then as I say, on the 14th, I then go to Boston, but on the 13th, I will be traveling to London on the 13th. So I probably won't be streaming on the 13th either, because I'll be traveling to London the day before, staying in a hotel the night before I fly. Fly me to the moon and every day, because my flight's like 10 o'clock in the morning or something like that. Whatever so they changed my flight, so it's like 10:30 in the morning or something it is now. So I'm going the night before, and then so I won't be streaming on the 13th. So but I'll be getting some vlogging stuff for you. So and I cannot wait. It's good. There you go. Right, close that down now. Fly me to the moon. Spacey Stacey's been in there. There you go, Spacey Stacey. Love it. She's in the group already. Loves it. I didn't put an explanation on it, but it's just like, you know what it's about. Let me get this down. Fly me to the moon. No movement. Hour and 40 minutes, apparently, since, 3:08. So, since they went. And we're going to be here all night long. All night. What are we doing? We're going to be here all night long. All night. So we need to keep the content going. So we've also got a new trial we're going to be covering. But I think we started tomorrow, day behind. So they're on day 2 today, but day 1 is only like an hour. Day 2 is today. So what we'll do is we'll zoom through day 2 and day 3 tomorrow. And that's what we'll do. Fuck it. Let's be rebels. And we'll do today. We'll just hang around. Hey, Katie. Well, we love having you here, my darling. So it's good. Once I get a little bit tired, bored, I've played day 1. It's an hour long. I'll play it. But, for now, we're looking at Dana's crotch. Kurt's crotch, and Dennis's crotch. And what have we got here now then? Okay. Right. Hang on. Dennis is here, so let me phone Dennis. He's back online. I'm not sure if he'll answer because he might be out, but we could ask. Hang on, before I do that, let me wash my hands. Right, let me ring him now, see if he'll answer. Stephen Stearns was, but he wasn't in court today. There was only a hearing, I believe. Yeah, I don't think Stephen Stearns was in court today himself. Just there was a hearing. Ba-da-da-da-da. Ba-da-da-da. Hang on, I need to do this first before I do that. Ba-da-ba-ba. Ba-da-da-da-da-da. Hang on, where's this gone? So Stephen Stearns did not appear at a hearing today. His attorney successfully petitioned the judge to postpone his trial on sex crimes charges. So it's been postponed. Why are you not listening to me then? Hey, Lady Di, why aren't you listening to me? Aren't I motivated enough for you? I'll be like, Lady Di, get on with it. Get your ass going. Can you hear it?
Hello?
Mr. Sweeney, you alright?
How are you, sir?
Good. Hey, you're on the stream. You're live.
Oh, okay. I'm sorry.
No, it's all good. No, just in case, I wanted you to know, just in case, you thought something. Right, everyone can hear you. Right, hey, listen, whilst you were away, me and Dana, we got a plan, right? We were wondering if you were interested in it, right? So, because I need to lose weight and obviously get fitter, right? And you're obviously very fit anyway, so you're all right. And you walk a ton. Well, you walk a ton, so it's fine. So me and Dana, right, are going to be doing, between your house and my house is 3,100 miles, right?
Okay.
So we're doubling that to 6,200. And then we're doubling that to 12,400, right? So we're going to do 12,400 steps per day, which, 6 days a week, 74,400 steps a day.
Wow.
We're doing that. Lots of people in chat are going to be walking, obviously not the same miles, but hopefully you can join in, do something, get you out there, get you fit. Are you going to join us in a bit of walking every day, Dennis? And let's go.
Yeah.
You do it anyway. You walk every day anyway, don't you?
Yeah, I never count steps or anything. How many steps there? I have no idea.
No, well, can you measure your steps then?
Yeah, I can put it on the my phone probably.
Yeah, you can. Yeah, so there you go. You don't have to do the 12,400, obviously, but count how many you do. It'd be good to see, And then every Monday, then we'll all say how much we've done for the week and stuff like that. So me and Dana are going to try and do 74,400 steps per week, which is equivalent to 12,400 per day.
That's a lot. That's all good. Because they usually say they want you to do 10,000, right?
Yeah, well, they say 11,000. So 5 miles is 11,000. So, and because Dana came up with the idea saying your house to my house was 3,100 miles, it just makes sense. It's got some meaning behind it, And that's what it is. So I can always say, why are you doing this for? Oh, we're doing it for the Boston trip, to lose weight and to get fit there, and because I can't have you running rings around me in Boston, Dennis. Do you know what I mean? I can't have that. You put me to shame, So.
I know I don't do that many steps a day because I'm with the dog, but I go up hills and stuff.
Yeah, you probably work out a lot more than any of us do, but it's just it's just a bit of fun anyway, It's something to push ourselves, and to challenge ourselves a little bit. And it's also one of those things that every time you think, oh, should I just walk here or should I take the car? Sometimes let's just walk then to see, So, so we're gonna give it a try anyway. So, and if we fail any week, then you've got to give us a beating. You got to beat us up. So well, you could beat Dana up, okay? Every week because I'm not there.
Too bad I didn't measure from my couch, my refrigerator. I'd be more into that one.
I can imagine. Well, I need to lose a ton of weight before I come to Boston, so I can put weight on in Boston. Do you know what I mean? So.
Oh, you're gonna believe me.
I know. That's why I need to lose weight before I get there. So, yeah, no.
Oh, that's great.
No, good. Well, listen, there was only a quick call to let you know that we're doing something about it. So, you can be on our backs if we're slacking. You could be like,
All
oh,
right.
come on.
All right.
Right.
Okay, good.
All right, buddy. I'll speak to you later, Dennis. Love to Brenda.
All right. Give my love to all my chatty friends out there.
They're listening to you now, so it's good. Happy days, Den.
I just walked up at the door just a minute ago.
There you go. Well, I was waiting to see you back online. That's why I was going to call you earlier, but you were offline. So I was like, I won't bother him, just in case.
No worries. I'm always around. If I'm not home, I'm in the woods with her walking somewhere. So.
There you go. All right, Dad. I'll catch you later, buddy. All right?
All right. Thanks.
Bye, bud. Bye.
Bye-bye.
So there you have it. If Dana fails any weeks, then we got Dennis Sweeney going to give him a beating. So... Well, Erin Hack's here now, is she? She's giving some lip here, is she? Erin Hack. Hey, are you joining in, Erin Hack? Because you need to join us in as well. You can hold us accountable on this walking malarkey. So we got challenge of walking 74,400 steps a week. Not a day, a week. Sorry if I said day. Erin Hack. So, why? Because we're wicked smart. No pyramid schemes for me. Right. Oh, okay, that's interesting. So yeah, just showing us support for our newfound cult. Well, as I say, it's the toughest week for me is week 10. Week 1 to start it, but week 10's gonna be tough because I'm in Dublin, so that's gonna be fucking tough. Oh, I suppose not, actually, because I'll be walking around, won't I? I'll be doing touristy stuff, so actually it's not going to be that bad for me, I don't think. So it'll be fine. Actually, that actually would be ideal. Anything I'm involved in, Hack does not show me support. Right. Shall I find this thing for tomorrow for you guys? Hang on, where's it gone? Don't know what that's for. Week 1's the hardest. Yeah, I thought it'd be Dublin week, but actually it's not because I'll be doing touristy things that week, so it's fine. Where is it gone? I'm trying to find the trials, people, that we'll be covering next. We've done that hearing. Fly me to the moon and tell me ba 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 Jupiter and Mars. Right, I got this. Let's put this into testing then. Let's have a look here. Let's have a look with a broken This means I'm probably gonna have to use Lord Klim probably. Dana the Speedo Man. Yeah, but we could be doing the same, aren't we? Loser of the week, there's the next full day of steps and Speedo, following along by Dennis in the car shouting obscenities. As long as we do it together. I think if you fail one week, I failed. So we've got to encourage each other. This is called teamwork. This is the one time we're actually going to have to be serious and do it together. Forever, together, forever. Right, Zachariah. Is it that one? Hang on, I got the wrong one. Copy. You'll be there when I emerge from a dungeon. Dana is our elected fall guy just in case someone slips. Lol, Dana is about to be tough as nails. Dana is going to be the tough guy in all of this. All right. We could be covering the Rose Petal trial. I know nothing about, well, I just roughly know some bits about it, but not much. Let's have a look here then. Right, it's a bond hearing from 2 years ago. No, we won't do that one. I need to know what the fuck this is about, first of all. Right. Unfortunately, we're going to have to do a recap via Law and Crime. Here we go. Right, hang on. All right, okay, I get it. Right, so here we go, people. Let me get this up. So this is the next trial we're covering. It's already live, but we'll catch up with it. So here it is.
That's Zachary Hughes. He's a classically trained pianist, and now he's accused of murdering a woman in South Carolina. I'm laying out everything that you need to know about the case dubbed the Rose Petal murder and the death of Christina Parcell as Hughes's trial is set to begin. Welcome to Crime Fix. I'm Anjanette Levy. I want to start by telling you this case has tons of twists and turns. It's sad and really disturbing. So I'm going to do my best to kind of weave you through all of this. The victim in this case is Christina Parcell. She had a 9-year-old daughter. On October 13th, 2021, Parcell was found murdered in her home in Greenville County, South Carolina.
Investigators rushed to the scene and discovered the victim had been brutally stabbed multiple times, resulting in her death.
The solicitor, that's the prosecutor, would later say that Christina Parcell was stabbed 31 times in the head and neck, and there was something about Parcell's murder that seemed ritualistic. Investigators said they found Parcell's body surrounded by rose petals. It's something that seems oddly personal. Why would someone commit a murder and then drop rose petals around the body? Parcell worked as a veterinary technician.
Right. My first question is, like, when she says that, why would anyone drop a rose petal? Why would somebody kill somebody? That's the fucking first question. Do you know what I mean? This is why I hate all these people. Oh, it's personal. Why do people put rose petals on there? Well, why the fuck did anyone kill her in the first place? That's more. Oh, I hate that narrative. It must be him. It must be personal.
And by all accounts, she was well liked, and the crime shocked the community. The Carolina Hound Rescue posted on Facebook a day after the murder. Christina was not only one of the most epic vet techs to our dogs, but she was a friend with a personality the size of a high-rise and always trying to make everyone else feel better. I can't tell you how many times she walked me to my car after an appointment and had me crying from laughing so hard. The dogs loved her, and she did such an incredible job with them. When you are at the clinic, as much as we are, you form friendships with some of the people that work on your dogs. It is hard not to. Christina was one of them. She always had an ear and always tried to make you smile, even in the worst of situations. Now, days after Parcell's murder, detectives took her fiancé into custody. But he was not charged with murdering Christina Parcell. Bradley Post was charged with several counts of sexual exploitation of a minor. The charges stemmed from evidence detectives said they found at the crime scene. After Parcells' murder, investigators said they found thousands of images of child sex abuse materials on Post's electronic devices. A couple of days after that, another man was charged with a crime, but again, the charge was not for Parcells' murder. John Mello is the father of Christina Parcells' daughter. He was charged with custodial interference for taking the girl to Italy in the fall of 2020. Then, less than 2 weeks later, Greenville County Sheriff said they made an arrest in Parcells' murder. This man, Zachary Hughes, was charged with murdering Christina Parcells. But why? Hughes was a former Marine and a classically trained pianist who studied at the Juilliard School in New York. He'd later moved to South Carolina. The solicitor said that neighbors' ring cameras captured Hughes entering and leaving Parcells' home. And he also said during a hearing that Hughes' DNA was found under Parcells' fingernails. But what was the connection, if any, between Hughes and Parcells? Well, it's John Mello. Investigators have said that Hughes cleaned Mello's home, and when Mello was arrested for custodial interference, he listed Hughes as someone he could communicate with in the jail. And detectives have said the two talked on WhatsApp a lot, and one of those conversations took place on the day of Christina Parcells' murder. Both men have been accused of harassing Parcells prior to her murder. Hughes has pleaded not guilty, and jury selection in his trial will begin on January 13th.
Why, this is very confusing. This is like a trifecta. There's a murder, there's a PEDO, and there's what? And these two communicating, what? I don't.
13th. I want to take just a moment to tell you about Upside.
No, fuck off. I don't give a fuck about Upside.
First tank of gas. That's promo code LCTake included with a lot of players in it. So I want to bring in somebody who can clear up the confusion and really boil this down to what it is. And he is Will Folks. He is the founder and executive editor of Fitz News in South Carolina, and he knows everything that goes on in the news in South Carolina. And he's been covering this case from the very beginning. So Will, what exactly is the connection between Zachary Hughes and Christina Parcells? We know that he's accused of murdering her.
Well, that's right. And prior to Zach Hughes' arrest in early November of 2021, there was no known connection between him and the victim in this case, Christina Parcells. So it came as a huge shock to folks when his arrest was announced, because up until that point, there was absolutely no connection between the two of them. Now, as this story has unfolded over the past few years, we have learned that Hughes has a friendship with an individual named John Mello. And Mello is a self-styled music producer who is a former boyfriend of the victim who had a child with the victim, Christina Parcells. And so apparently those two have been connected. In fact, they've been charged together actually with harassment. This took place in September of 2023. Prosecutors in Greenville County charged the two of them with harassment related to some obscene pictures that were mailed to neighbors of Christina Parcells as part of an effort to harass her. But again, this arrest came out of the blue because when this incident took place in mid-October of 2021, for several weeks, everyone just assumed that the person who would be arrested would be the individual who found her body, her boyfriend at the time, who's a gentleman by the name of Bradley Post. However, again, that didn't happen. It went in a completely different direction. And what's even crazier about this story is that the individual arrested, Zach Hughes, not only was there no known connection, but this is like the least likely profile of a ritualistic killer. I mean, this is a guy, classically trained pianist, someone whose background would seem to lend itself to playing recitals, not stabbing someone 31 times in the head and neck area with a knife.
Mm-hmm. And the solicitor down there in Greenville County has said that in previous hearings or in court documents that this is their guy, Zachary Hughes. And the musical connection, that makes sense. But why this guy, Zachary Hughes, would actually carry out a homicide and then put rose petals around Christina Parcells' body, that that's just confounding to me. But the solicitor said that Zachary Hughes's DNA was under Christina Parcells' nails. There's apparently video of him with a hoodie on entering the house. So they seem to think they have a really strong case.
Yeah, the forensic case here is very strong. In addition to the DNA evidence that you referenced in the camera evidence, they found the bike that he was allegedly traveling on as he left that neighborhood in Greer, South Carolina, which is a suburb of Greenville, South Carolina, the big population center in the upstate. But yeah, the case against him is very strong. Now, what's also interesting, Anjanette, police are pouring through WhatsApp messages that were allegedly exchanged between Zach Hughes and this John Mello individual, where they go back and forth trading cryptic messages. And there's one really interesting exchange that took place the day of the murder. In that exchange, Hughes is asked how the music lessons went. And he responds to Mello, good, I'll tell you. And so police and prosecutors believe that this may have been code for carrying out this, just, again, as you mentioned, graphically ritualistic execution, in addition to the multiple sharp force injuries that the victim sustained. As you mentioned, her body dragged across this home, was posed with deadhead roses or rose petals, depending on who you talk to, sprinkled around her body. So again, whoever, again, was behind this wanted to send a clear message, and folks are still scratching their heads at how that could be Zach Hughes. It just doesn't seem to fit the profile.
So if prosecutors think they were speaking in code, they must not have enough evidence then to charge John Mello, unless John Mello might be cooperating. I just don't know. I mean, he's out walking the streets as far as I know. And he had been charged with, there was some kind of custodial interference case because he was the father of Christina Parcells' child. He had taken the child overseas. And then there's this whole other aspect of this case involving Bradley Post, Christina Parcells' boyfriend, and there was apparently some sexual exploitation of a minor material found on his phone. So he was taken into custody. And now Zachary Hughes's attorneys, they want to access that because they believe that could somehow help them with their defense, right?
I think it absolutely would help. I mean, here's the thing we've got to remember about this case. We've got just this horrific crime, but the victim was accused of doing some pretty horrific things as well.
Right. There's some bestiality allegations. She worked at a vet's office, right?
Yeah, there are some bad allegations. And in fact, Bradley Post, her boyfriend at the time of her murder, the individual who found her body, he's been criminally charged by the Office of South Carolina Attorney General Alan Wilson with numerous charges, including bestiality, including criminal exploitation of a minor, first-degree charges. And these are charges that carry lengthy prison sentences. So it's serious. Apparently more than 50,000 images and videos of child porn or child sex abuse material, as it's termed now, were located at the scene during the search. And so it's just a mess all around. And so the argument by Zach Hughes' attorneys is, the victim had it coming, I guess is the basic argument.
Wow. The victim had it coming, though. I mean, that's not a defense to murder. I mean,
not in my mind,
I just
no.
I can't see it. I mean, if there were some allegations that she was engaging in activities with a minor that she shouldn't have been, involving sex, I mean, you call law enforcement. That isn't, you do a murder. So I don't know.
You need only one juror, Anjanette, and that's the problem.
That's true.
You get one of the 12 to buy into that theory that this was a somehow justifiable slaying, then that's all you need. And I'm 100% with you. This United Healthcare thing, as I've seen the reaction to that play out, it's kind of horrible to think we live in a culture that people believe they have the right to take matters in their own hands like that. Hopefully this case won't come down to that. But again, if I'm his attorneys, I want that discussion front and center. I want that jury thinking along the lines of what a terrible, terrible situation was befalling this poor young girl that was in the custody of Christina Parcells. And I want them transferring that to try to think of Zach Hughes as someone who, again, in this horrific way, delivered her from that. That's what I want if I'm a defense attorney.
Yeah, maybe they're looking for one juror or possibly jury nullification. We don't know. Is there any way that Zachary Hughes takes the stand in this trial?
Oh, what stupid fucking question.
That's an interesting question. We have seen very little out of the defense as far as strategy or what they might attempt to do. All we've seen so far is efforts by the prosecution, which is led by an incredibly capable solicitor, Walt Wilkins, up in the 13th Circuit. He's a very good attorney. He's been up there for a while, knows the courtroom inside and out. He's going to be a very formidable prosecutor, him and his team. But the attorneys representing Zach Hughes, also very adept. So I fully expect this to be maybe not Murdoch level in terms of the back and forth between the attorneys, but very close to that, because these are some incredibly skilled lawyers. And again, the prosecutors want to keep this child porn stuff out. They want to keep it away from the jury. They don't want that to be any part of their thinking. But the problem is Bradley Post, the guy who's been charged with all these horrific child porn charges, he's their witness establishing the discovery of the body. I mean, they literally have to call him. So I don't know how you get out of that. It's a real double-edged sword for the state as they try to prosecute this case.
Yeah. That would be difficult. I don't know how they do that either. It would take a lot of tiptoeing, some very talented lawyering. Well, we will be keeping an eye on it, and we appreciate you coming on to talk to us about it and to try to untangle.
This sounds like I didn't know any of this stuff. So this trial sounds loony. This is like a head that he was loony boo. Loony. So the way I look at that, so allegedly this Zach guy broke into the house, unalived her. Then as they her current boyfriend found her, they did investigation. They found lots of kiddie stuff and bestiality stuff on the laptops. So he got arrested for that because he was involved. Allegedly, she's involved in that as well, with children as well, and with animals. And her ex-boyfriend, the husband of her child, got done for taking the child to Italy, but now he's allegedly worked with Zach to kill and alive her, but he's still on the streets. And Zach was arrested. So this is... Shall we watch day one? Day one is like an hour. It's pre-trial motions. Let's watch it. This is an hour, people, so let's watch it because we've got time, so I might as well watch it. So this is the pre-trial motions. Right, hang on. I just pulled up the gym. Hey, lazy, you're supposed to go, no, I love your voice. We'll do whatever you want. So Deb's not here, but I'll still boost it for Deb. There's only like 10 people here, so I don't think people are interested in this trial, but it doesn't matter. I am. You are. Hey, let's go. Right. Let me bring my banner down. Ba, 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 ba. Let me bring my banner down. Ba, 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 ba. Let me bring my banner down, banner down, banner down. There you go, banners on. Right, here we go, everybody. Zoom, zoom, zoom. Did anyone say zoom, zoom? I did. So this happened yesterday. Katie, lovely Katie's always here. Thank you, my darling. This happened yesterday, people. So just people thinking, what's this? Pre-trial motion yesterday for the trial. Right, let me fast forward then to... Here we go. Is it muted? No. Oh, fuck. Let's get going, shall we? Oh, here we go. Judge coming in.
Please take a seat. Thank you so much. Okay, I want to make sure that we go through a couple things before we get into the motions.
Hi, Crystal.
First, I know that we are going to have, obviously, a media presence, and we welcome you. Our courts are open to the media. I do want to make sure that everyone in the media has received a copy of my order. When we were initially going to trial, I had an order, then I did an amended order, and then, of course, I just did an order for this trial that we're in now. But please make sure that you have that. And again, I welcome you to our courtroom. I do want to just say a couple of things, though. And I think that you all are probably fully aware of this, and this is really for your protection. But you are not to use the name of a minor in any reporting. And also, I have gotten a couple questions, recurring questions about my order. There is going to be a 30-minute delay. And again, I just ask that you abide by that order. I also ask that there not be any reporting on anything for a 30-minute delay consistent with my order. And if anyone does not understand that, just please contact my office or the clerk. Okay. All right. Solicitor.
Your Honor, just one housekeeping matter or matter that we wanted to raise. From the defense perspective, Your Honor, we have no objections to the manner of selection and the composition of the jury, Your Honor. Wanted to raise that with you, but we have no objections.
Yeah, and I appreciate you doing that. That was on my checklist of whether or not y'all had any objections to the selection of the jury. Thank you, Mr. Mormon.
And the state does not have any objection either.
Okay.
To the selection of the jury.
So no motions pertaining to the selection of the jury in this matter. Thank y'all. All right. Let me double check. The state had initially filed a motion in limine. Later, the state filed an amended motion in limine. And I think that we will hear that one first.
Yes, Your Honor. The state filed a motion for a gag order specifically regarding the accusations that were alleged by the defense counsel against the victim, in this case, Christina Parcell. And it was in conjunction with our motion to exclude evidence relating to the case against Brad Post, who is going to be a witness in this case. Your Honor's familiar with. He's been charged by the state of South Carolina as being prosecuted by the Attorney General's office for sexual exploitation of a minor. That case occurred about 2 weeks. Those charges were brought against Brad Post about 2 weeks after the murder of Christina Parcell, and about the same time that the defendant in this case was charged. And so we filed a motion for a gag order for the purpose of keeping those statements out of the record and out of the press and from reporting on it, because the state felt that it was prejudicial. And it was in conjunction with our motion to exclude evidence of child pornography that is allegedly found on Brad Post. And I say allegedly because Brad Post has not been convicted. He's been charged with sexploitation of a minor first and third, and I believe buggery, based on lots of videos and photographs that were located on his phone and thumb drives and computers. He just happened to be the fiance of Christina Parcell. And so we've asked this judge, your Justice Honor, one, to keep the defense from putting those in their motions. Put those things in their motions so that that information, which has been unsubstantiated at this point in the trial, at this point in our procedure, and if it was necessary for a filing, to redact it so we could keep it out of the hands of the press and a potential jury. In addition, the state was attempting to comply with the Victims' Rights Act as well, which a victim, in this case, Christina Parcell, has a right not to be shamed and ridiculed in the case against the defendant who's allegedly committed this murder. So that's sort of gone on, and that we filed that back in October, Your Honor. And at this point, the state withdraws that motion for a gag order as we've now picked a jury, and so it's basically moot at this particular time. And then we'd like to move on to hear the exclusion of the child pornography evidence or anything related to the Brad Post case in there for the purposes of this trial. I'd like Your Honor to hear that. I know we've done the motions, and I know you have something to say about the gag order.
Yeah, and just for the record, I mean, you've withdrawn it now, but I would be denying that. And just for the record, I have reviewed Nebraska Press Association versus Stewart, N. Ray Murphy Brown, LLC, State, Rec Co. versus State, State versus Price. And again, I would be denying that motion if it was not withdrawn. I also would note the case of Ex Parte, capital U Drive It, in which it stated, quote, judicial proceedings and court records are presumptively open to the public under the law. And First Amendment of the U.S. Constitution and the State Constitution, Article 1, Section 9. I do want to note for the record that at no time has there been any order by any circuit court, any judge here that has ever sealed any of the filings that have been made. It's my understanding, for the record, that the state specifically asked the clerk's office to hold certain filings. And so I just want to make sure that the record's clear and that the clerk will be instructed to make public any filings other than, I guess the gag order does not need to be filed. Okay. All right. We will move on with your motion, which is your motion in limine, amended motion in limine.
Yes, Your Honor. Yes.
When you're ready to proceed.
Okay. Thank you, Your Honor. Yes. So the state filed an amended motion in limine to exclude any reference to any evidence of the child pornography. I say the alleged child pornography. Again, has not been substantiated in any court, as Brad Post has pled not guilty to those cases, to his particular case. All of the items were found on devices in his possession or under his control. And so our first argument, Your Honor, was that in this particular case, in the case of who killed Christina Parcell, Zach Hughes has been charged with that crime. That particular crime that may or may not have been committed by Brad Post has absolutely no relevance to this particular case. And so that's of course our first argument of that. And we highlighted in our motion, Your Honor, the highly prejudicial effect of putting in the fact that child pornography may have been on some of his devices there. And I cite State v. Cooper as well. Evidence we can have no other effect to cast a bare suspicion upon another or raise a conjectural inference that the crime was committed by another is not admissible. But not only is there conjecture, Your Honor, there is absolutely zero relevance to any and all child pornography to this murder case, and there's no nexus, and the defense cannot provide a nexus at this stage in the process. And so, Your Honor, we would ask you to exclude any and all reference to child pornography, which goes to also Brad Post's testimony as well. We've also asked this court to limit the testimony of Brad Post. And for the record, Your Honor, his attorneys asserted a blanket Fifth Amendment protection on his behalf in relation to that. It's my understanding State v. Lawrence is the main case on that as well. And the key to that is that he's not an inculpatory witness. He's at the bottom of the chain when it comes to evidence against Zach Hughes. His testimony will be, I've never even met Zach Hughes. I don't know Zach Hughes or anybody that from in the public. And so Zach Hughes, the name of Zach Hughes will not come out of his mouth other than I don't know who he is. So by allowing impeachment evidence, pursuant to Rule 608 and 609, diving into his current charges, because they're not convictions yet, of a non-inculpatory witness is what State v. Lawrence and others stand for. And so when you have a non-inculpatory witness, your ability to go into their potential impeachment sort of diminishes and it lessens as you go forward. All the other cases that we cited, Your Honor, are folks who were eyewitnesses to crime or they were in the car before a murder happened. In this case, Brad Post is merely just going to talk about how he arrived at her house at around 11 o'clock on the 13th and found her deceased body inside his house, her house, and the house where she lived with her sister and her daughter. So we would ask this court to restrict that any mention of that evidence on those grounds in relation to Brad Post, as well as the impeachment. We would ask this court to limit the impeachment or the conversation about his pending charges to, have you been charged with a crime? Would be the extent you can go into his pending crime now that he's defending against. Otherwise, Your Honor, at the end of the day, going into his particular crime would serve this jury absolutely no purpose as to whether Zach Hughes committed this crime or not. Again, at this stage in the proceedings. So we would ask, Your Honor, that. And we would also ask you to restrict the defense's ability to cross-examine him on that particular area. As, again, it's not relevant and it's extremely prejudicial. And I remind Your Honor, if this jury hears about any child pornography related to the victim in this particular case, you cannot unring that bell. You cannot unring that bell. And it is highly, highly prejudicial to the victim in this case. It is a violation of the Victims' Rights Act unless there is a mechanism and relevance and a path to that evidence at some point in time. And Your Honor, the state believes there is no path to that evidence. There's certainly no path to that evidence at this stage in the game, and before the state has even permitted any or presented any evidence to this jury. And so we certainly would ask, Your Honor, to restrict that. And if you do restrict all of those things, we would ask that we don't need an in-camera proffer of Brad Post. As far as the state's questions, we have gone over those. I've submitted those to the court. I've submitted those to defense. Brad Post has responded to those. He did not assert his Fifth Amendment right on any of the questions that the state begins to ask. And so by allowing the defense counsel to get up here and ask him questions they know he's going to take the fifth on, or in that square box of child pornography related questions, it would really just allow them gratuitous information into the world that has no bearing on this particular case. And so we would ask, Your Honor, there's no reason to have an in-camera hearing and restrict their cross-examination and of course our direct examination to non-child pornography related testimony regarding the defendant and the victim in this case.
Anything else from the state?
Not at this moment.
Your Honor, may it please the court. First, a timeline I think would be useful. The state moved to exclude this evidence in September of 2024. In November, we had a bond hearing for our client. After the bond hearing, the state instituted the motion for gag order and sometime around in there amended the motion in limine. So, Your Honor, I would argue that timeline, I don't think necessarily they were in conjunction with each other. Your Honor, this I just have to deal with this from the get-go. The state has told Your Honor once again that these allegations related to the child pornography are, quote, wholly unsubstantiated. This is a refrain that we've seen repeatedly in the pleadings from the state. We have made it very clear in our pleadings in response to theirs that we in no way want to discuss this topic irresponsibly, discuss it gratuitously, but over and over again, when the state alleges that it's wholly unsubstantiated, we just have to address that, Your Honor. It is highly substantiated. We have evidence to show that. And as an officer of the court, I've represented that in pleadings. Mr. Moyer has represented that in pleadings. And that evidence exists, and we're prepared to introduce that evidence. But I want to set that straight. That evidence exists. We're prepared to show it and prove it. As it relates to what the ask is in the motion, extraordinary relief they are seeking. 16,000 or more images of child pornography. We have photographs. We have videos. They want Your Honor, without having seen any of it, without having it introduced at trial, any exhibits whatsoever, to categorically exclude 16,000 or more pieces of evidence that we may or may not seek to introduce. So they want Your Honor, again, to, from the bench, without any evidence introduced of any kind, without opening statements, with nothing, they want Your Honor to exclude that evidence.
Mr. Mormon, assuming that is the case, their point still is, I don't care if you have 45,000 videos, it's still not relevant, is what they're saying, if I understand correctly. So relevant being makes a fact and issue more probable than not. It is highly relevant. We've also, there are cases that discuss relevance in the context of Rule 402. Relevance relates to evidence that helps the jury get at the truth. All right, and I would actually cite State versus Sweat for that proposition, and I can give you a cite on that. But relevance is evidence that assists the trier of fact, in this case, the jury, to get at the heart of the matter, to get at the truth of the case, right? And the truth of the case, the bases for the relevance in this case are enormous and will become much more clear after the trial starts. And that's one of the reasons why Your Honor should, at a minimum, decline to rule on this issue until the trial starts and Your Honor can see some of the evidence and what the cross-examinations are. But Your Honor, to again, in a vacuum, to exclude this evidence before Your Honor's had a chance to review it, before it's even offered as evidence, I'm not even sure how you do the 403 analysis, right? Because it's such a fact-intensive analysis. The other thing is when the state argues that it talks about prejudicial evidence. Absolutely. Every piece of evidence the state seeks to offer against Mr. Hughes they believe is prejudicial to Mr. Hughes. Every piece of evidence, should we decide to do that, we offer is going to be prejudicial to the state. But it's not unfairly prejudicial. This evidence is not unfairly prejudicial, Your Honor, because this evidence came to pass based on, in no small part, the actions instituted by Brad Post, who was engaged in this illegal conduct with Christina Purcell. So, Your Honor, it's highly relevant. Your Honor, at this time, there was a discussion about the impeachment and the nature of the charges. Oh, I also want to clean up one fact, and then I'm going to turn it over to Mr. Moyer. The state indicated that in the timeline that Ms. Purcell passed, and then a couple weeks later, Mr. Post was charged with violations of South Carolina law. The timeline is this, that Ms. Purcell passed on October the 13th, that there was one warrant for for sexual exploitation of a minor, 3rd degree, obtained by the Greenville County Sheriff's Office on October the 19th. So 6 days. 6 days after law enforcement obtained an arrest warrant for Mr. Post. And they continually obtained warrants after October the 19th, culminating, I believe, on November the 23rd, wherein they obtained an arrest warrant for Mr. Post for criminal sexual conduct with a minor in the 3rd degree. But I just wanted Your Honor to be aware of the fact that 6 days afterwards, the Greenville County Sheriff's Office obtained a warrant for Brad Post. Now I would defer to Mr. Moyer to talk about cross-examination related to Mr. Post pending charges and applicable sentences or potential sentences.
May it please the court, Your Honor. So there are really 2 issues that are associated with this. Is one, should we have an in-camera hearing for Mr. Post? And the second is, what can we ask Mr. Post about his pending charges? So beginning with that first issue, I think we clearly need to have the hearing, Your Honor. The state expressed concern that we don't want Mr. Post just being asked a lot of questions that he's going to plead fifth to. Well, that's exactly why we need to do this outside the presence of the jury, so we know what he's going to plead to fifth to and what he's not. So we're not just stopping every few questions, having to send the jury out and then hash it over. So, we're prepared to ask him the questions. We're prepared to hear what his answers are, and if he's pleading the fifth, and if he's doing so properly, then we can let that lie. But Your Honor needs to be able to vet him to make sure that he's not pleading the fifth irresponsibly. That is a question that he should answer, then he needs to answer it. So we would ask that we have that hearing tomorrow morning. We think the hearing should last 30 minutes or so. So I think that would be a wise use of the court's time and would save a lot of problems throughout the trial. The second issue, Your Honor, is whether or not the the defense is allowed to cross-examine Mr. Post about his pending charges and about the penalties. And if it please the court, I did prepare a brief, we did prepare a brief memorandum that talks about some of the cases that I'm going to mention now. And Your Honor, just to give you a little background, Bradley Post faces 9 different charges. So he has 1 charge of criminal sexual conduct with a minor 3rd degree. That charge is violent. It carries up to 15 years in prison, and it is carries automatic sex offender registry. He has 5 counts of sexual exploitation of a minor 1st degree. Those charges are violent. They carry sentences that range from minimum of 3 years with no parole to 20 years, and sex offender registry is discretionary. He has 2 counts of sexual exploitation of a minor 3rd degree. Those carry up to 10 years in prison and discretionary sex offender registry. And then he has a charge of buggery that carries prison for up to, that carries a 5-year straight prison sentence with mandatory sex offender registry. Now, Your Honor, the law in South Carolina is crystal clear that the defendant's Sixth Amendment rights are violated if he is not allowed to question a state's witness about pending charges and the penalties. I'm not aware of a single case in South Carolina where the defense was prohibited from cross-examining a state's witness, and on appellate review, it was not ruled to be error. And that goes not only to naming the charges, but to bringing out the penalties. And I'll go over 4 cases very quickly in a minute. But before I do, I think what is especially telling on this point is the fact that the case that the state uses, State v. Smith, is a case in which the Supreme Court ruled that it was error for the defendant not to be able to cross-examine a witness about the charge that was pending against him. In that case, they just mentioned that he had pending charges. The defense was not allowed to go into what the exact charges were, and the Supreme Court said that was error. Now, in that particular case, they found it harmless error, but it was error nonetheless. And there are multiple.
Mr. Moore,
yes, sir.
And I know I'm interrupting you.
That's quite right.
As we go along to ask questions. In that case, the witness, was it someone who was a co-defendant?
Your Honor, in that case, No, it was not. It was someone who testified. He was a victim in the robbery case. He testified about identification of the robber, who was the defendant in that case. That person had pending carjacking charges. And actually, in that case, what happened is the state actually dismissed that charge that morning in an attempt to try to keep the defendant from being able to ask about it. This was actually a PCR case, and Supreme Court ruled that it was deficient of the defense attorney for not pressing that issue and striving to have that charge named. Again, in that particular case, it was found to be harmless. There are a few cases where the courts have found it harmless error. There are many where the courts have overturned convictions, murder convictions. And so basically what you're being asked, it appears, Your Honor, is to just go along with the erroneous ruling, and let's just hope that the Court of Appeals finds it harmless. So so that's State v. Smith. Now there are other cases, Smalls v. State. That is a case where the Supreme Court overturned the conviction because the defense attorney was found deficient for not attempting to impeach the witness with the charge and potential penalty. There's a State v. Gilliam. There, it's a burglary case. There was a co-defendant in that case, and the defendant was prohibited from questioning the co-defendant about the penalty for burglary first degree, which was 15 years to life. And the Court of Appeals found that to be error and overturned that conviction. State v. Mizell. In that case, the defendant was denied permission to question a witness about pending charges and was denied being allowed to ask about potential sentences, and the court overturned that conviction as a violation of the Sixth Amendment. And then State v. Sims, Your Honor. In that case, there was a state's witness testified, had numerous pending charges unrelated to the murder case that was before the court. He had drug charges, grand larceny, robbery charges, and the court ruled that the specific charges could, the trial court said that the specific charges cannot be mentioned, only that he had pending charges, and that was found to be error. So, Your Honor, in this case, I think the law in South Carolina is crystal clear that when a state's witness is cross-examined and he has pending charges, he can be asked about what those charges are and what the penalties are. And so, Your Honor, we would seek to do that.
Does it matter to you that it's the AG's office as opposed to the solicitor?
It's the same party, Your Honor. It's all the state. So that does not make a distinction. It's in the 13th Circuit. It just happens that and I don't think it matters. I think the charges could be in Richland County. It could be in North Carolina. What matters is there are pending charges, and the implications that somebody testifying with pending charges, even if they don't have a deal. In fact, it's even more relevant when they don't have a deal, because the courts have ruled that that person is going to be going out of his or her way to try to ingratiate himself to the prosecution, so that down the road, when he or she comes before a court for sentencing, that person can say, Judge, I cooperated with the state. You need to take that into consideration. I testified. And so whether there's a deal or not, whether it's in 13th Circuit or not, whether it's being prosecuted by Mr. Wilkins' office or not, they're pending charges and they need to be asked about.
So that's your argument for 608C bias?
Yes, sir. Not this time. Thank you.
Yes, Your Honor. Briefly, I'm going to have Mr. Hoforth respond to the Smith case, but Your Honor, this is a simple issue. The defense cannot establish any relevance whatsoever to the case against Brad Post that, number one, I can't give Brad Post any deals because I'm not prosecuting him. So it is very relevant, that issue. But what is on Brad Post's phone has nothing to do with this case, and they still can't establish a nexus to it. They can't establish any relevance to any of that. And until they can do that, there's no reason this jury needs to hear anything about what's going on with Brad Post and his separate crime. Because, Your Honor, whether they like it or not, Brad Post is not on trial here. Zach Hughes is on trial here. And so the fact that Brad Post may have child pornography on his phone really has no place in this courtroom here today. Mr. Hofer is going to respond to the State v. Smith, and I think it's related to the fact that Mr. Post is not an inculpatory witness, and that's what they keep not wanting to talk about. All the cases that Mr. Moyer is talking about have an eyewitness to a crime, somebody that's very inculpatory to the defendant. Mr. Post is not going to inculpate Mr. Hughes one iota, and therefore your ability to go down a rabbit hole into some pending charges that he's not pled guilty to is limited in that respect.
Thank you, Your Honor, and I'll be as brief as possible, but it's important to start with the foundation here where we're talking about the testimony of Brad Post specifically and the nuance with this case with the backdrop of South Carolina law. I cited Smith and Mitchell in the state's brief because they are the most pointed to the circumstances related to this case, but really the circumstances related to Brad Post's testimony go a step further to warrant the exclusion of such cross-examination as to the sentencing he might potentially be facing, or even the naming of the specific charges. I'll note that the two cases that Mr. Moorman went into great detail on, Gilliam and Mizell, both of those instances are where the witness is charged with the same crimes that the defendant is facing. So obviously that would be probative upon cross-examination to even if there's not a deal in place to pry as to the potential bias of that specific witness. But starting with your ability to tailor this to the specifics of the case, and that comes from the United States versus, I'm going to mispronounce it, but Frederick, F-R-E-I, right, Frederick. It really needs to be a case-by-case analysis. And in Smith and Mitchell, those two witnesses were eyewitnesses, inculpatory witnesses to the crime itself, and then charged with collateral, offenses. In both of those cases, the Supreme Court or the court held that the only essential information that was excluded from cross-examination was defense counsel's latitude in being able to name the specific charges with which that witness was charged with. Not to get into sentencing, not to get into what they were potentially facing, only what the specific charges were. Now, this does also go in conjunction, like most all things in this case, going back to the state's motion and why we filed it with such advance to exclude such mention of child pornography in this case, because we are necessarily eliciting on direct examination that Mr. Post is charged with a crime. Yes, that he is currently in jail. Yes. But as soon as the cross-examination comes out and the question is asked, well, you're charged with criminal sexual exploitation of a minor, that opens Pandora's box in the present case. And of course, look back to exactly what he's testifying to. He doesn't know who the defendant is. He did not know at the time of the crime, on October 13th, 2021, who the defendant is. He is testifying necessarily because he found the body of Christina Parcell, because he received envelopes going toward the harassment charge of Zachary Hughes. And mind you, he didn't even know who sent those harassment envelopes. And he's testifying to the blanket, to the bare minimum that he was in a relationship with Christina Parcell to explain why he would show up at the house on the morning of the 13th. This is not an individual who says this is Zachary Hughes who committed the murder, who provides any evidence towards attributing Zachary Hughes to committing this murder. So it is completely within your discretion to curtail the cross-examination, to not elicit the charges, but certainly not the sentencing that he faces and opening that door.
And Your Honor, I refer you to 610B. It says cross-examine on any matter relevant to the issue in the case, including credibility. So even the rule contemplates relevancy.
May it please the court. And the relevancy, Your Honor, is bias. And that is a hugely relevant point in any cross-examination. I'd like to read just a little bit from State v. Gilliam. It says the fact the witness has yet to reach a plea bargain or been found guilty should not prevent the admission of such evidence. The lack of a negotiated plea, if anything, creates a situation where the witness is more likely to engage in biased testimony in order to obtain a future recommendation for leniency. Accordingly, we conclude the Court of Appeals erred in holding the trial judge properly excluded testimony concerning Steele's potential sentence if convicted of the same crime as defendant. Included in the confrontation clause protection is the right to cross-examine any state's witness as the possible sentence faced when there exists a substantial possibility the witness would give biased testimony in an effort to have the solicitor highlight a future court how the witness cooperated. So there's no distinction about whether the person is testifying about something that's inculpatory or not, about what the nature of what the person is testifying is about. And if the state can find any case where it makes that distinction, we would love to see it because it's not there. And because oftentimes we don't know when a person testifies, sometimes it does not become clear how significant that testimony is or what implications are of that testimony until down the road we start hearing from other witnesses. It just comes down to the fact that if it's a bright line rule, if he is pending charges and he testifies for the state, then it can be asked about. And just one other point, Your Honor.
The witness, was Page in State versus Gilliam?
Let me look at my notes, Your Honor.
Was it a co-defendant? Was it somehow tied in with the crime?
I think Page was a co-defendant in that case.
And just with I think with the Gillian case, it was a murder case. He was tried for murder. The murder burglaries. Well, the murder weapon was obtained in a burglary previously that Page, the cooperating witness, participated in. But you know, I would just reiterate what the import of their argument is. Judge, if the witness is really testifying about something that hurts the defendant, then he can be cross-examined on this. But if it's really not that big of a deal, if it's not too inculpatory, then his credibility is not a big deal. There's just not distinctions out there on that. If they put this witness on the stand, this witness has a motivation to curry favor, to get help on his pending charges, then that's open season. That's what the confrontation clause allows. And what Mr. Moyer has said is so true, that case after case after case, trial courts have been reversed when they've sought to limit cross-examination on pending charges and on possible sentences. There's no distinction that we've been able to find in that, period.
You're going to have a witness up here just asserting the fifth over and over and over. And of course, that gets to why you feel like you need to have the in-camera hearing.
And you know,
On the Fifth Amendment and the Sixth Amendment,
But Your Honor, there's no conflict here because by saying what he's charged with, that's a matter of public record. By talking about what the possible penalties are, in doing that, he in no way, that's not inculpatory. He says, I know I've been charged with this. I mean, it's like when he's arraigned and they ask him, do you know the nature of your charges and the possible penalties? He says, yes, that's not incriminating.
Thank you, Erin. Hang on, people. I'm just getting the.
We're listening.
I think they're going home for the night.
All right. Through the court officers that they're ready to stop for the night. I'm going to bring them in, give the admonitions, and send them to the hotel.
Okay, they're just stopping for the night. Okay, well, which means we after we finish the other one, I'll stop as well.
6:02.
6:02 they stopped.
Everyone stand, please.
Stephen Stearns has been postponed, Mexi, I believe. It's been forwarded on.
You may be seated. Thank you.
All right, ladies and gentlemen. I'm going to go through these admonitions again. You're not to communicate with other jurors or anyone else regarding any subject connected with this trial. You're not to form or express any opinion about the case until it's finally submitted to you. You're to report promptly to the court any incident involving an attempt by any person to improperly influence any member of the jury or a juror's violation of the court's admonitions. You're not to read, watch, or listen to any news reports concerning the case. You're to decide this case solely on the evidence introduced in the trial. Now, when you get back to the hotel, you're not to deliberate. You only deliberate in that room. That's 11. I don't think we have Ms. Rucroft. They all left you. Okay. We'll go through this one more time now that we're all back together. You're not to communicate with other jurors or anyone else regarding any subject connected with the trial. You're not to form or express an opinion about the case until you finally decide it. You're to report promptly to the court any incident involving an attempt by any person to improperly influence any jury member or a juror's violation of the court's admonitions. You're not to read, watch, or listen to any news reports concerning the case. You're to decide this case solely on the evidence introduced in the trial. All right. Yeah, you can go with the officer. Have a good evening.
Thank you, Mexi. Terry, thank you, Terry. I showed up as a juror and never returned from the first break this morning or something. Yeah, no, they're just in the toilet or something, I think. There you go, Terry. Mexi's done it for you. Thank you, Terry. Let's go into this one then. The other trial. Hang on. We're going to listen to this and then we're done for the night. Then I'll set up tomorrow's stream now.
So I would argue there's no conflict here between the Fifth and Sixth Amendment as it relates to the Fifth trumps, right? Confrontation clause. If there's a conflict, but if he's asked what are you charged with and what are the penalties, I just don't see how he can take the Fifth to that.
And we're not getting into where at this point, as we discussed in chambers, at this point, we're not getting into, where this sexual exploitation of a minor came from. We're not going to be talking about it coming off of his phone or who the victim is or anything like that. Just that he has those pending charges. And as far as the jury knows, these could have been pending from 10 years earlier. There'd be no connection at this point between him and Parcell. It just goes to bias. So there's no reason for him to.
But there's no question. It's my understanding, and y'all correct me on this if I'm wrong. Okay, 9/11 will corroborate that he was going there, correct? The 9/11 call.
If they, I don't know if they plan to play that or not, but.
Yes, we do. Okay. So to that point, I mean, attacking him on bias when he's telling something that's clearly a fact that even y'all would probably agree to. And then I guess the other things that they plan on getting in with him.
Judge, there are multiple things. They're going into these mailings that were sent, having to do the harassment charge. They've already called Bradley Post a victim. So if he's a victim of these mailings, then this gets into implications of our client. So we have, and once again, there's no distinction in any of the cases about what the witness is testifying about, like how damaging it is to our client. It's just the fact that he is testifying and he has these pending charges.
All right, anything else, Mr. Porter?
Not this time, Your Honor.
This is gonna end.
Okay.
I'll be very brief. I'll just note that where Mr. Mormon is claiming that there's no differentiation, I suppose that ignores the factual analysis that the court goes through on each individual case in describing the pretense to the witness testifying, where the court always makes light of the importance of the witness's testimony, and that's noted in Delaware versus Van Arstal when they are reviewing this for harmless error analysis. And the importance of that particular witness's testimony is, I believe, the first factor that they analyze. And the hypothetical that the state put in its brief, or not the hypothetical, but the reality of when we're talking about what is the impact or the bias value of asking that question from the defense's perspective, given what Mr. Post is testifying to. So you elicit the question, aren't you charged with criminal sexual exploitation of a minor? Does that make the fact that he found her body that morning less likely? Does it make the fact that he received envelopes less likely? Does it make the fact that they were in a relationship less likely? Or what doubt does that cast on those bare factual bases that he's going to provide? And that is the distinction when the courts are analyzing this as to the importance of the witness's testimony to the state's case. He is not sitting there saying Zachary Hughes sent those envelopes. Zachary Hughes committed this murder. Then, of course, where you would get into that same line of cross-examination, of course, that would project bias on the weight of his accusation towards the defendant. But we don't have that here. So that distinction is critical for the court to take note of. And that's why it is within the trial court's discretion to tailor the scope of cross-examination on a case-by-case basis, depending on what that witness is going to testify to.
And, just very briefly, what Mr. Hoferth was talking about right there, it goes into the analysis of whether it's harmless error or not whether it's error. So it is clearly error not to allow these questions to be asked of the witness. And courts are not supposed to analyze and try to drill down on what exactly the import of this particular evidence is. I mean, otherwise we would have every witness who's testifying for the state who happens to have pending charges. We'd have to have in-camera hearings. How important is this evidence? Is it going to, how damaging is it to the defendant's case? We don't do those analysis. It comes down to a bright line test. Again, is it the state's witness, and does that person have pending charges? And I'll.
I'm going to take a little while. I'll get y'all ruling this afternoon. Hopefully I will not take too long. I mean, y'all have done an excellent job on the briefing. So to a certain degree, I've had a heads up on what I need to rule on. So, okay. We will take a break. Can't tell you how long. Hopefully it won't be more than 15, 25 minutes, and then we'll be back.
I don't think he comes back. But I think what his decision was that he's ruled that they can't bring it in. They can't bring it in. What? Yeah, there's something about a missing juror. There was a missing juror. Are you talking about the missing juror in the jury just now? She was just in the toilet. Is that the one you're talking about? Or is it a completely different juror? Because they were 15, 3 were sent home, and there's 12, at the end there was 11 jurors, and one was lost, but they found her. She's in the toilet, and they brought her out. Or is this complete? Did they bring in an alternate? That's what I'm confused about. Let's just finish setting this up then. Before closing, that's fine then, because obviously they were 16 then, because 3 alternates were let go. They would have done that off camera, so that's fine. As long as it was done then and not afterwards, then it's fine. Hang on then, let me just do this then. I'm just trying to do one other thing here, and then I think I'll be done then. Do a stream, put that in the afternoon. Schedule for later, tomorrow. I love you tomorrow. And do that one again. Apply it. Create live stream. Right. Both streams have been done. To be fair, I didn't know what you're on about, because I'm trying to set everything else up. I just saw something about juror missing. I've not read chat, so I don't know what you guys are on about. So that's fine. I'm just now catching up. Hey Keith, no, it was this morning before closing arguments. He's not listening to me. I was doing my streams for tomorrow. Yeah, it could be anything. You're right there. As long as it was done beforehand, it's fine. Because he did let 3 jurors go, which then makes sense if they had 3 alternates go. But that's just normal anyway, isn't it? So it's no biggie. Hang on, let's look at this then. Where's that gone? Over here? No, the wrong one. Too many tabs open. I need to close them. Okay, fine. Right, everybody. Thank you very much. We will. I mean, it is normal. It is normal for jurors to leave. Do you know what I mean? We see it all the time in juries that they just things crop up. They just have to leave. It's not one of these things where, whoa, what the fuck? A juror left. It's like, it happens. Life happens to people, doesn't it? So, right, this is why we have alternates. Right, everybody. Do you remember that Kitsap trial where the guy did like 4 months, and then he left after the 4 months because he had a holiday? That sucked for him. Right, everybody, take care of yourselves. We'll be going live at 1:45 tomorrow. We're going to be zoom in because we got that other trial at day 2, which was done today. Yeah, we'll do it that way. We'll probably play this a day behind a little bit for now, and then catch up as we can. I'm not going to pushing it, but I might do 2 days tomorrow. We'll see how we feel. Thank you, Mexi. Thank you, everybody, for being here. And we shall see you all tomorrow at 1:45 Eastern. Bye-bye, everyone. Take care. Love you all. Because this is going to be a very interesting trial, I think. This one, because it's confusing as fuck. See you in a bit. Ta. Hey, see you, Stacey.